Audio stream check.
Yeah.
That's what it feels like anyway. I don't know if I can revive anyone, I might put somebody to sleep.
Audio stream check.
Oh, yeah. Yeah, sometimes in the past, I mean, it depends on where you put it. Here, I think they've seen them do it right in front of you if you access, or your cubby over here,
Audio stream check.
wherever you want to do it.
Good morning. Today is June 24th of 2024, and the current time is 9:01 a.m. The commission has set aside this time today for an evidentiary hearing in the matter the staff of the Missouri Public Service Commission, Complainant, versus Leon Travis Blevins, also known as Travis Blevins, and Patricia Blevins, doing business as Misty Mountain Public Water Supply, also known as Misty Water Works, Charity Public Water Supply, and Rolling Hills Public Water Supply respondents. My name's John Clark. I'm the regulatory law judge presiding over this hearing today. We have a fair number of people in attendance. If you have a cell phone, I'm going to ask that you put that cell phone on silent or vibrate so that it doesn't disturb proceedings today. If you are participating in today's hearing and you're at one of the council tables, you'll notice that there's a microphone there. When you're speaking, please be sure that the green button is lit so that we can hear you, and likewise, please be sure the button is not lit when you don't want to be heard. Now, the Missouri Public Service Commission is composed of 5 commissioners. There's Chair Kayla Hahn, and Commissioners Maida Coleman, Jason Holzman, Glenn Kolkmeyer, and John Mitchell. And several of them are present via WebEx right now, and I expect some of them to appear in person today, and others will continue to listen via WebEx. But they will be listening and asking questions whenever they would like to. And commissioners, good morning. If you have questions during the course of the hearing, please feel free to interrupt me and ask them at any time.
Thanks, Judge.
Thank you, Commissioner Holzman. At this time, I'm going to ask counsel for the parties to introduce themselves, starting with Mr. Blevins. Mr. Blevins, you are representing yourself, correct?
That's correct.
And you don't have an attorney, and none is going to be appearing on your behalf, correct?
That is correct.
Okay. On behalf of the staff of the commission.
Carolyn Kerr.
And Casey Aslin.
Thank you and good morning. Anyone here from the Office of the Public Counsel? I don't see anyone at this point, but they can always make an appearance in this case if they so choose. Are there any preliminary matters that the commission needs to take up at this time before we start?
I don't think so. I'm just going to number the exhibits as I go.
That would be fine.
Okay. I don't think I have anything.
Okay, and just to go over the order of witnesses real quick today, from staff we have Jeff Grube, Lori Jean, Jackie Johnson, Dalton Young, Adam Stamp, and Kurt Gately. Is that correct? Mr. Blevins, do you have any witnesses that you're going to be introducing today?
No, sir.
All right, I'm going to go by the list and order of witnesses and statements for this hearing. So I'm going to go ahead at this point and start with opening statements, starting with commission staff. I'm going to remind everyone that an opening statement is not evidence, but it merely frames the coming proceeding for the commission. So it's kind of an introduction to things that you would like the commission to pay attention to. So, Mr. Blevins, I'm going to swear you in before your opening statement. Should you choose to make one, just because you're acting as your own witness today, you may say things throughout the course of the hearing. Can you hear me okay?
I have a little bit of difficulty.
Okay, I can see you're giving me a little bit of a quizzical look. If you can't hear me, would you let me know?
Yes, I will.
Okay. As I was saying before your opening statement, I'm going to go ahead and swear you in, and the reason why is because you're acting as both your own attorney and as your own witness today, and you're going to be questioning witnesses, you may say things that have evidentiary value, and because of that, it's almost like you're on the witness stand all the time in some respect, because you may say things that may in fact be statements. So I will be placing you under oath at the beginning of the hearing for the duration of the hearing, okay?
I understand.
Okay, thank you. Commission staff, do you have an opening statement you'd like to make?
Good morning, Judge, Commissioners. May it please the Commission. My name is Carolyn Kerr, and I'm the attorney representing the staff of the Public Service Commission this morning in this case. The staff has filed a complaint against Mr. Leon Travis Blevins pursuant to its authority under Section 386.390.1 RSMO and 20 CSR 4240-2.070, alleging violations of Chapter 386 and 393 RSMO and asking for specific relief to be granted, including monetary penalties. I'll get to those statutes and regulation in further detail in a moment, but let me first tell you about the facts of the case and what led us to this hearing. This case is about protecting the residents who use and consume the water provided by the wells owned and operated by Mr. Travis Blevins, or Leon Travis Blevins, an individual who took it upon himself to charge those people for the water that flowed from those wells. Mr. Blevins does not have any license or other authorization from the PSC to charge those residents for the use of water that comes from his wells. He did not bother to apply for a Certificate of Convenience and Necessity, or CCN, from the PSC to be designated as a water utility and have the authority to charge fees and rates for the use and consumption of water from those homeowners until after the PSC began investigating his business practices, notified him of the need to be regulated to charge residents like he was, and brought this action. Instead, he just decided on his own that he would charge residents that obtain water from the wells he ostensibly owned a certain level monthly charge. He even drafted contracts and demand letters and provided them to the homeowners and either had them sign them, agreeing to pay Mr. Blevins a fixed monthly payment for water, or just demanded payment without an underlying contract. Mr. Blevins' method of calculating the rate, we learned, was that he just figured out what a good price would be to cover his expenses and charged homeowners for that amount. And not all residents paid the same price, nor had to make payments in the same manner. Some paid in cash, some monthly, some as they could, and he even bartered goods and services for payment of some of the water bills. And no one complained for a while. That is until problems with the wells and the water quality started to happen more frequently, and the monthly rates went up for no apparent reason. Then in January 2023, the PSC Consumer Services Department received several complaints from homeowners stating that Mr. Blevins raised their monthly water bills and they didn't know why. They had received new or updated letters. Some got contracts, but they all had questions and concerns. About the same time as the complaints regarding the water bills came to the Consumer Services Department of the PSC, the Missouri Department of Natural Resources, or DNR, had also contacted the Water, Sewer, and Steam Department of the PSC with their concerns about Mr. Blevins' well systems. They had been receiving calls from some of the same residents complaining about their drinking water and asking what DNR could do about regulating Mr. Blevins' services. Now, DNR doesn't regulate water utilities or rates, so they contacted the PSC asking us for advice. All DNR could do basically is test and regulate the water coming out of DNR certified wells and issue violations for poor water quality. DNR could not do anything about the wells or well systems that did not meet DNR standards and were therefore not regulated by any agency, but were still being used to supply water to residents. Jackie Johnson and Dalton Young from the DNR will testify as to their roles with DNR and how they've been involved with Mr. Blevins' case over the course of at least the last couple of years, as well as their connections with the PSC and its investigation and case. Those homeowners calling DNR wanted someone to do something about Mr. Blevins charging them for potentially unsafe water. It was at this point that Adam Stamp, a PSC staff research data analyst, and Kurt Gately, the manager of the PSC's Water, Sewer, and Steam Department, became involved and began investigating. Both of these individuals will testify and tell the commission what they did as part of their investigation, as well as what the staff's role is when it comes to unlicensed or unregulated water utilities.
Ms. Kerr, can you move the microphone just a little bit
Oh,
closser?
sure.
Some of the people online are having a hard time hearing you.
Sure, I'm sorry. Mr. Staff's main investigator for this case will testify about the many times he went to Pulaski County and saw the sites for himself and spoke with the residents who were getting their water from Mr. Blevins' well systems, as well as the problems they had with the water, the wells, and the trouble they had getting Mr. Blevins to fix the problems. Jeff Grube, a homeowner and former customer of Mr. Blevins, is here to testify about his experience dealing with Mr. Blevins and his system. His house is no longer connected to Mr. Blevins' system, and he will testify about how that came about and what led to it, the reasons for that. Ms. Lori Jean will also testify as to her experience dealing with Mr. Blevins and his well systems. She was Mr. Blevins' former certified operator for his DNR-regulated well systems until March of this year. Mr. Blevins has been without a certified operator since then and has not replaced Ms. Jean. DNR regulations require him to have one for each system he owns or operates. What staff found was an unregulated water utility owned and operated by Mr. Blevins, who was and continues to charge multiple homeowners monthly charges for water use based on no discernible rate formula or other mathematical calculations from wells Mr. Blevins may or may not even actually own, according to Pulaski County recorders or Mr. Blevins' own records. Furthermore, the water coming from those wells has and continues to pose health and safety concerns for the residents who use and consume the water that Mr. Blevins is selling them. In fact, Mr. Blevins has failed to submit required bacteriological water testing samples to DNR since February of this year. So no one knows what kind of water quality any of those residents are using and drinking, and that's just the ones DNR regulates. DNR records show a pattern of violations dating back years and a pattern of Mr. Blevins' failure and inability to fix, maintain, and upgrade the wells, water lines, well houses, and appurtenances to keep the wells and water lines in working order so that the families that live there can have consistently safe and potable water. In other words, staff's witnesses will explain how Mr. Blevins and his business enterprise is operating a public water utility subject to the Commission's jurisdiction, control, and regulation pursuant to Section 386.020 sub 43 RISMO, and how he's operating that water utility for gain without a certification or other authority from the Commission in violation of Section 393.170.2 RSMO, and in a manner that endangers and is a threat to the public health and safety in violation of Section 393.131.1 RSMO. As a result of its investigation, the staff filed this complaint to bring to the Commission's attention the violations being committed by Mr. Blevins and his business enterprise and the health and safety concerns of both staff and the Missouri DNR so that corrective or preventative actions can be taken to make sure the wells and the water coming from them are safe, as well as to safeguard the health and safety of those that obtain their water from Mr. Blevins' wells. Staff asked the Commission to hold Mr. Blevins accountable for those violations and exact penalties against him for the harm that his actions and inactions have caused and continue to cause the families living there that rely on the water from Mr. Blevins' currently unregulated and uncertified water utility. Thank you. If you have any questions?
Thank you. Any questions from the Commission?
No questions, Judge.
Thank you, Commissioner Holzman. I've got just a couple. You had indicated that you had discussed the ownership of the wells.
Yes.
And that it was unclear as to what wells Mr. Blevins owned. Now, in the Commission's May 20 order resetting this hearing,
Closer to the bathroom.
I've got somebody who is, okay. In the Commission's May 20th order, I indicated that one of the issues that the Commission wanted to hear about was the ownership of the wells. So is the ownership of the wells something that's going to be sorted out during the course of this complaint?
We're going to try.
We're going to try, okay. The second thing is you indicated that some people that were formerly customers would be testifying today. Is that correct?
Yes.
Now, obviously, if we're going to get into, I'm not aware of what all the confidential information in this hearing is going to be. If we start to cross into confidential information, I'm going to rely on the parties and particularly the Commission staff to let me know so that we can go in camera if necessary.
Okay.
All right. I have no other questions. Thank you.
Thank you.
Mr. Blevins, did you want to make an opening statement?
I would, I think,
Okay, I'm going to place you under oath then.
okay.
Would you raise your right hand to be sworn? Do you solemnly swear or affirm that any testimony you give at this evidentiary hearing will be the truth?
Yes, I do.
Thank you, Mr. Blevins. And do you want to make your opening statement from where you're seated?
Yes, I'd like to remain sitting here.
Go right ahead.
Thank you. Well, good morning, everybody. The best I could do here is absolutely give you the truth, where it began and I guess where it's going, maybe, in reference to these water wells. I acquired these water wells from individuals that were operating these wells for the last 15, 20 years, possibly. Don't know really how long. I won't mention the particular names at this present time, but listening to the opening that Ms. Kerr just did, when she mentioned about what I do on myself, or from myself, this is, when I acquired these wells, that was the way that it was everybody paying for that water. They had been doing that through some sort of an agreement between the person operating it and the users for 15 or 20 years or so. That was just the normal thing to do. There was no water available by any other utilities anywhere around the area. These were builders that have subdivisions, and primarily these wells were built for that subdivision, not for the general public. If you didn't own a piece of ground there, you didn't, you weren't allowed to get water by any means. He indicated there was no license. I still don't have a particular license for these wells. The wells are non-compliant, and I guess they have been since the first time that they were ever built by these builders. I don't suppose at that particular time there was any license that's being issued. I suppose if there was, they would have already had it. But that was the commonplace in the use of those wells. They mention of a CCN. I did apply for a CCN, but quickly found out that this really could not be applicable, in my opinion, to what we were doing with these wells. These wells were not constructed, built, or used for any type of profit. It was just built for use of the homeowners that would buy these homes from the builders. So I requested, I thought, during the first two proceedings, I believe, of this particular commission meetings, that my application for that CCN be withdrawn. And again, I say it right now, I would withdraw any application for a CCN as non-applicable. The well problems. One of the reasons why I acquired these wells is because from the builders that I knew, and had done a lot of business with in the past, these wells were coming up for their lifespan of 15, 25 years or so. We already knew that. I knew that when I acquired them. So I took on that responsibility to repair these wells. I've upgraded most every one of those wells in the past. Throughout the process of me when I acquired these wells, after I acquired them. So well problems were evident, and it was also my responsibility to go in and repair these wells, which I did on every occasion that I can remember, recall, or whatever. I immediately went into the process of upgrading particular wells, and almost every one of them that I've had has been upgraded or improved. I don't know really what it means by trouble fixing, as Mrs. Kerr alluded to, that trouble fixing. I did fix these wells. They're operating today, and they have been. They've never been down for any particular reason. There's been certain things done to these wells. On some occasions, it's the maintenance or the fixing of these wells is kind of minor. On other occasions, it's not minor. It begins with $1,000 brackets. It takes money to do that. Where that money comes from was generated from the people that use the water by their monthly payment. Nobody ever likes to see things or prices increasing, but I guess today in our economy it increases almost every day, or every month, or every year. These wells have been built 15, 20 years ago. It's obvious that these wells are going to cost more now than they did back then. Just as an example, some of these wells that may have been built for $8,000 or $9,000, $10,000 now cost $30,000, $40,000, and $50,000. These are some of them 5-horse pump, some of them 3-horse. These are the systems, the distribution systems that were put in, cost money in order for these people to have water available to them in that subdivision. That's what it took at that time. So, an operator. When you talk about an operator, I don't suppose 15 years ago they required any operators that I'm aware of, unless you were a particular type of utility company providing water. I don't know. But the ownership of these wells was a beginning problem. 15, 20 years ago, they did easements. They did all kinds of other things that sometimes did not really get done properly, maybe. And there is obviously some of the problems that has arisen has stemmed from not being properly done in the beginning. That was one of my jobs, was to, at any particular time in the future, from the time that I acquired these wells, is to make those corrections, which I have in most instances. There are still some instances that still have to be done, still have to be corrected, even by the legal part of it. If we have a well sitting on somebody's property and it has not been properly, let's say, surveyed, and that well described on its own, then that is a problem that had to have been corrected. I corrected a couple of those already. There's a couple that still probably need to be done. But it only needs to be done at some particular time that maybe a disposition of that property would take place. Not just go in there and start making things all the way it should have been 15 years ago in the present world that we live in, and with the present guidelines and rules that have been changed from 15 years ago. That's ownership. Ownership was given to me by just certain individuals, very few, either by some sort of contractual agreement or by a deed. Some of them I do have deeds to, but I'm not concerned about whether or not, personally, I have a deed for a particular piece of property, because of the people that I deal with that operated these wells previous to me. I was just carrying on what has been there for 15, 20 years to make sure that people did still have the water. And even today, they do have water. That was one of the reasons why I took these wells. Not took them, but acquired them. Was to make those corrections as requested, and I knew all of these problems were there. And again, I've corrected as it became necessary. I've corrected those particular problems that should be corrected for the current rules, regulations. I've been working with the Department of Natural Resources for since 2023 with the 3 public water systems that they activated. They activated the Misty Mountain Public Water System, the Charity Public Water System, and the Rolling Hills Public Water System. Again, I'd like to indicate that the Misty Mountain Public Water System activated by DNR, individually the wells would not qualify under the DNR guidelines as a something that they would take control of or have control over. They had to combine a number of wells in order to make that particular rule effective to activate that Misty Mountain Public Water System. They had to combine those. I guess just because I either owned or have control of those particular wells. Also, the Charity Public Water System was the same condition. It had more than one well. They were separate wells for separate parts of the division, but they put them together to create and activate that public water system for Charity. The only one, which is Rolling Hills, that qualifies to have 15 connections or a number of 25 users, which the rule, I guess, from my learning from the DNR, providing a lot of information in reference to these public water systems, that the users are multiplied at 2.5 or 2.5 times however many connections there are. So that that particular mathematical equation creates maybe less or more than 25 users. Or the other guideline that we have to deal with is the 15 connections. So the 15-25 mathematical equation qualifies a particular public water system, I assume, from all the guidelines. The most part of trying to give you an overview of where I began. I think maybe that the Rolling Hills is the only one that really qualifies. My process at the present time is to continue to follow the Department of Natural Resources guidelines and the agreements, so to speak, between the public water system and DNR. my wife and I have already signed over the Rolling Hills agreement to the DNR. We're working on the charity public water system with some changes. I would expect it would be rewritten a little bit and provided back to me to sign. At the present time, the Misty Mountain public water system has activated by DNR. That was there was no agreement there. That was just simply directed to be what it is today. But my process for the Misty Mountain public water system is to eliminate the wells so that they do not meet with the continued 15 connections to 25 users. DNRs are aware of that. I've made that known to them. And in particular, the Taylor well, for example, that Taylor well was sold by me to a party that was on that particular well using water. I spent $12,000 just upgrading it so that it would be available to all of the users there. I sold it for $12,000 just to tell you what I received there all went back to the improvement of that particular well. But the well itself still had a little problem even after that. And with the new owner, excuse me, the new owner of that particular well at that time was supposed to improve it or be a part of improving it. It was operational after I had finished that, but there was an improvement that could have been done. It never was done by the new owner. So,
Mr. Blevins, you're veering a little off of an overview of, you're veering a little away from an opening statement's overview of what testimony is going to be, and you're starting to bleed into what testimony is.
okay, all right, I can kind of tie this up. I think is that that a lot of these verbiages that are being used here appear to be something that I've done wrong. Maybe I have, I don't know. But that was not any intentions of why I acquired these wells. It was acquired in order to improve those wells, which I did. So as we get on, I guess, into more of the testimony or whatever, I can expound more at that time. Is that correct?
That is correct.
Okay, thank you. I'll go ahead and just close my opening statement at this time.
Okay, thank you, Mr. Blevins. Are there any questions from the commission?
Yeah, Judge. This is Commissioner Holzman. I have a couple.
Go ahead, Commissioner.
Thank you. Thank you, Mr. Blevins. How many current customers would you say you are servicing today?
I would have to check my records, but that would be probably, let's see, give me just a moment. Less than 60.
Less than 60?
That's correct. That's within those three public water systems.
And of those 60, how many do you have written contracts or agreements with?
Well, I should have one for all of them, every one of them, but a lot of times when we send them out in the past, we never got them back on some occasions, but I would say I've got probably maybe 60%, 70% maybe written written agreements to furnish water.
And what is the methodology you use to determine your rates?
Well, the actual just expenses per month or per year. For example, when one of the reasons for raising a rate, that when DNR activated the wells into 3 public water systems, that created extra expenses. My calculation was approximately an increase of $1,000 per month. So we increased, I think, $5 or $10 on the particular monthly rate that was being charged. Also, in the beginning, when I first acquired these, the the charges that were being currently done at that time might have been $35 or $40. We have since then evolved to $55 per month.
Now, you said in your opening statement that there's no profit. You're not doing this for profit. How is that an accurate statement that at the end of the year there's no additional revenue that would be considered net profit for your 60 customers?
That's correct. That there is no profit. The improvement or the upgrades of those wells far exceed the cost. Far exceeds what's even brought in today. When most of the improvements paid for have been paid out of my pocket, obviously from some of the sources of the income that comes in from the users, but that has never been enough to cover all the expenses. I would have hoped that it would have eventually evened out or panned out to be at least.
So I'm curious, why do you operate them? What is the inherent benefit to you to go through the the daily routine of operating these wells if there's no benefit to you financially?
Well, I can explain it this way. The people from whom I acquired these wells from were good friends of mine. They still are. And I have done business with them for years, and I still do. I'm 80 years old. I wanted to quit doing what I normally do, which is construction or any other type of physical labor. My medical conditions also required me to stop doing strenuous type work. So I wanted something that would be less stressful on me personally. I chose these water wells from these individuals because I knew that I could upgrade them and eventually have a cash flow maybe from that, but not particularly as a profitable situation, but a cash flow situation that would work. And
All right, thank you.
I still believe that that's possible, but maybe not so much now. I'm 80 years old and not much time left to consider that maybe.
All right, thank you for answering my questions. Judge, that's all I have. Thank you.
Thank you.
Thank you, Commissioner. Are there any other commission questions at this time? I hear none.
Yes,
Oh, I'm sorry.
I do
Go
have
ahead,
some
Chairman.
questions as Commissioner Hahn.
Go ahead, Chair.
Thank you. Mr. Blevins, back when we had your receivership hearing, the criteria for receivership had something to do with if you were able, unable, or unwilling to maintain the systems in the service. And at the time of that hearing, you did not seem unable and or unwilling. However, since that time, reading staff reports, it seems as though, for example, in Ms. Kerr's opening statement, she said that you had not provided DNR water testing information since February. Also, you had, and even today, said that you are withdrawing your application for a CCN. And you are you are in adversarial action with DNR on other compliance issues. So that brings me some pause. You were initially given some time to work with DNR because you did not appear unwilling, though I know this is the complaint case kind of getting to the receivership, but I'm hoping you can explain all of these actions and how that you are still willingly trying to get these wells into compliance and operating under the law.
I have never been or had the attitude of not complying. I've been complying to the best of my ability and knowledge diligently. I caught most of what you were explaining, but not all of it. The reason for not doing a testing of the water since, I guess, February or March, I don't remember which, is that I was under a different understanding. Lori Jean was previously our operator and the one that took all of these samples and reported them into the DNR laboratories. When she resigned, which is, I did not realize or was not knowledgeable, I guess, in the fact that I could actually have done that myself. Or had maybe one of my employees or somebody that I work with actually go out and do this water testing and turn it in, even through the public service there in Waynesville. I've recently learned that I can do that from Mrs. Johnson, Jackie Johnson at DNR. I did not understand that in the previous, so I was trying to find new operators, which was almost impossible for the Pulaski County area. But I have learned something since then also, which I have already done. I have already applied for or put my basically application in with the DNR Springfield department or branch, a Mr. McDaniel, to where I can attend the classes to acquire a DS1 permit or a DS1 certification from DNR, and that would suffice or replace the lack of an operator, and also give me more authority to do the testing, because even though I can do the testing now from my new understanding, which I intend to implement that in the first month of July, which is only a few days from now, to get the testing back in place. Excuse me. I've applied for that particular position and given, even though I can do the testing, and I still had to satisfy the operator requirement for the public water system, like Rolling Hills and the other two. So with the DS1, myself as the owner, I guess, I would satisfy that requirement for the DNR.
Mr. Blevins, you haven't addressed the CCN issue yet. You said you were withdrawing your application, but from my view, you still fall under PSC jurisdiction for regulation until you reach an agreement with staff, regardless of whether or not you think you do. The statute and the case law say if you're operating a system for gain, whether or not that gain is actually profit or not, it just is compensation. So can you say why now you are withdrawing your application for CCN?
Well, the reason, in my opinion, and when I received those 42 requests for information, I found that it was just really not possible for me to provide that to the staff. It was built more on the line of a utility company. I don't believe that these are actually utility companies that would fall under the for-profit. In fact, the 3 public water systems that I now have been registered with the state of Missouri as a not-for-profit organization.
Okay, that's helpful that it is now registered as a not-for-profit. I was unaware of that. That's helpful. Hopefully, I can look into that and verify that. Appreciate it very much. Thanks, Mr. Blevins.
Okay, thank you.
Are there any further commission questions at this time? I've got a couple of questions for you, Mr. Blevins. I'm going to save a lot for your testimony because I kind of want to go into more detail there. I'm going to follow up a little bit on what Chair Hahn said about CCNs. Why do you believe a CCN is not applicable to your systems?
We don't have a staff to go along with all of the requirements of the utility company, and it is, and it's still in my opinion that it's not big enough. There's each one of these water wells by themselves will not qualify for under the DNR as 15 connections or 25 users, except one, which is the Rolling Hills, which is only one well out there that's serving 18 connections at the present time. Well, there was 2 wells out there previously, but one of those wells was previously sold some time back. That was probably a mistake.
Well, I'm summarizing here. Is your argument is that it would be too onerous for you to be, or too much of a burden to be regulated?
No, 2 owners would not be the burden. The burden is all of the requirements that go with such a small amount of income.
Now you understand that the requirements to be regulated by the Public Service Commission are different than the requirements that the DNR may have in terms of number of connections for them to oversee it, correct?
No, sir. Not to my knowledge. What is the requirement then if the commission has different requirements? I assume I'm not familiar with it then.
Well, I understand you may have that question. I'm not here to answer questions today. Staff will be putting some witnesses on, and you're certainly welcome to ask those questions of staff's witnesses.
Yeah, I understand.
Now, you mentioned employees in your opening. Do you have employees?
No, I do not have employees.
Then why did you mention employees?
Well, I think I said employees or people that that work for me. They're either contract or maybe a different situation, not particular an employee. I don't regulate their time. Be subcontracted maybe.
Are these individuals you hire to do particular jobs on a well?
No, not any particular one. I may hire them to. I have one individual, which I don't now, but I have one individual that lives on the property, and he goes with me to service whatever I'm servicing, either in construction or wells or whatever. He's not an employee.
Now, at one point you used the phrase "turned a system over to DNR," and I didn't understand what that meant. What do you mean, turn a system over to DNR?
Turn the system over to, I don't know, I don't recall that. Turn the system.
It was just a phrase you used in your opening. At some point you said, and I turned the system over to DNR. I didn't understand what that meant.
Well, I also don't know what I meant in reference to turning it over to DNR. I don't know what I was referring to at that time, but I guess, or recall.
Are you aware of what wells you currently own?
Yes, sir.
And you know how you own them?
Yes, sir, I do.
So when you take the stand later, I'll be able to ask you about that?
Absolutely.
Okay, thank you. I have no further questions. Are we ready for our first witness?
Yes, sir.
Okay, staff, you may call your first witness.
I call Jeff Grube.
And Mr. Grube, if you'll have a seat right there. Before you sit down, I'm going to ask you to raise your right hand and be sworn. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Sir.
Please be seated. And you're going to want to lean into the mic when you're talking so that everybody can hear you, including the commissioners participating online. Go ahead.
Okay, thank you. Good morning. Could you please state your name and spell it for the record?
Jeff Grube, Jeff. Grube, Grube.
And are you employed by anyone?
Yes, I work with Humana.
And where do you live?
St. Robert, Missouri, down in Pulaski County, 24461 Tigger.
Excuse me, and how long have you lived there?
We've lived there since 2014. July 2014.
So about 10 years.
Yes.
Okay.
I'm going to interrupt for just a second. Mr. Grube, you were a former customer, correct?
Yes, sir.
And under the PSC's rules, customer-specific information is confidential. So you understand by testifying here today that you're waiving that and you're providing information?
Yes, sir.
Okay, go ahead.
Okay, thank you. And are you familiar with Mr. Travis Blevins?
Yes, ma'am.
How do you know him?
He lives approximately 300 yards down the road. He also provided water for us since 2016, up until February of this year.
And when you moved into the area, is that a particular subdivision that you live in?
It's the Misty Mountain subdivision,
Okay.
is what it is.
And you said which road do you live on?
Tigger.
Okay. And you said that when you first moved into your house, I guess first of all, who was the company or the entity that was providing your water supply?
So originally it was Jim Parsons owned the well that provided water. Don Baker ran it along with Baker Construction, who we paid our $30 a month to them at their business location. We paid them up until 2016. It was a known agreement that we had.
And then you said it changed in 2016. What happened in 2016?
In 2016, we were served with a letter in September from Mr. Travis Blevins that he was now going to be our utility provider for water. And we were to pay him directly.
And did you sign a contract with Mr. Blevins? Did you
We
get,
have never signed a contract, a service agreement, nothing with Mr. Blevins. The only thing we have received is, I'm your water provider, you pay me or it gets shut off.
and do you get water bills, monthly water bills from Mr.
No.
Blevins? Or did you?
Never received a water bill unless you were past due, then you got a notice it was gonna be shut off if you did not pay it.
So do you ever know what the rate was, like how that was calculated? Was it on usage, amount of usage, or do you know?
No, when we first purchased the home, we knew that, hey, it was a $30 flat monthly fee that we paid. They, like I said, Jim Parsons, Don Baker are the ones that managed it for the most part. Parsons is the one that did all the maintenance. We knew that it was a $30 monthly fee that we paid. We understood that without any problems.
Okay, and what happened when Mr. Blevins became your provider?
Well, whenever we had an issue before that, we would call Mr. Parsons, or we'd call Baker Construction, and they would respond really quick. They were very cooperative. They worked with us. They let us know what was going on. We didn't have issues. The well house was maintained and things like that. What we started to notice really was that stuff was kind of shady because we had to make our checks out. We seen different business names in the notices that we received. So when we received these, then we'd make the check out to that, and Travis would tell us, no, you have to make the check out to me. As well, it's just seen a lack of maintenance. I mean, you just see a pile of trash sitting outside of the well house, if he went into the well house ever. So it just became just an eyesore for our community, and it just kept rolling down that same hill. We had service interruptions that really started to upset us and have no response to those, as well as the increased rate hikes with no maintenance. I mean, that's kind of a open question with what the issues are, Ms. Kerr.
Okay. And you said you got, you were told to, I guess, make your checks or your payments payable to different business names. Can you explain what you mean by that?
No, whenever he would service his notices, one time it would say Misty Mountain Water Works, then it would say Travis Blevins, then it would say, oh, I don't even remember all the names
Okay.
on the forms. But basically, he would give us all these forms with business names on them, and then you would try to write a check out to him, to that business name, and he would say, no, you got to make it out to my name. So you couldn't write a check in his name. You couldn't put it in his mailbox because someone would steal it. So you had to hand deliver it to him, but you never could receive a receipt.
Okay. And were you able to mail in your payments before Mr. Blevins?
Before Mr. Blevins, we would take him down to Baker Construction, which is the building in St. Robert. I do not remember the address that Mr. Blevins owns now. We would go in and we would pay Baker Construction. He would give us a receipt right there,
Okay.
without a doubt.
Okay, Ms. Aslan is going to hand you what's been marked Exhibit 1. Those are three separate letters in that exhibit. Do you recognize those?
Yes.
And can you tell the commission what those letters are?
Well, the first letter, it was originally in 2018, and then it was duplicated again, as you can see, with the 1/9/20 date on there. But that basically listed that, hey, our fees were increasing to the $45 a month, along with the late fees and things like that. But as you can see, there's no agreement in any of this. You will pay this or your water shut off.
Okay.
And it's not a bill. This isn't something that we received monthly. This was once in a while we would receive notices like this, and this is how we would be informed that our fees were increasing.
And that-
or
that's,
changing.
you're referring to the first page there?
Correct.
And then what about the other two letters that are attached there?
The second one here is, let's see, let me read it quick. Oh, this is the one where Travis chose to inform me that we had not paid our water bill. So previously, we had paid 6 months or 12 months in advance, always. And I'd have to get the canceled check for this one here, but we were paid 1 year in advance. And he tried to tell me that we were not. Then he wanted me to go back and get all my canceled checks. And I said, well, there's one canceled check. I refused to do that because we paid every year, July to July. This is the time frame after this letter when we quit paying 6 months in a year at a block, because this was a common occurrence in our community.
Okay, so what did you said you quit paying 6 months in advance. What, did you start doing something different?
Yep, we started paying 2 to 3 months in advance at most until 2023, when we paid no more than 60 days.
And you remember,
That's what that note is on the back as well.
and you received these from Mr. Blevins?
Yes, ma'am.
Did you ever sign a contract accepting the terms of these of payment?
That was never an option. Like I said, you were given this by him, or these people that work for him are his grandkids, his granddaughter. They're the ones that work for him. So either Mr. Blevins would bring it to us, or his grandson would bring it to us.
Okay.
And that was all it was. There was no discussion. This is what you were gonna do, or it was dropped in our mailbox until there were complaints filed with the United States Postal Service.
Okay. And did he ever explain, or give you an explanation of how he came up with the amounts of the rates, the monthly rates?
No, when he was questioned about it anywhere between here and now, when he was our water provider, he's like, well, that's just the rate. He would say, once the DNR got involved and the PSC, that, oh, well, they're charging me over $1,000 a month, so I have to increase your rates. That's the only thing. There was no actual calculation or anything that he would ever explain.
Okay. I asked that, or moved that Exhibit 1 be entered into evidence.
Any objections to admitting Exhibit 1, the Misty Waterworks correspondence with Mr. Grube onto the hearing record?
No objection.
Exhibit 1 will be admitted onto the hearing record. Go ahead, Ms. Kerr.
And what was your, did you contact Mr. Blevins when you got these letters?
Well, I would call him, or I'd go out and meet him on the road when he goes to go by the house. Frequently outdoors, I'd see him drive by, because he drives by multiple times every day to and from town. So I would just go out and I would, hey, Travis, what's up with this? Or I'd stop in town at, I don't know what to call the place. Where he has an establishment in town with quite a bit of stuff around it.
Okay.
I think he's referred to it as an antique store, I believe. That's where I would stop otherwise and have a conversation with him,
Okay. And
or at his house.
what was the response that you get from Mr. Blevins
In regards to the rate,
in regards to these letters and the rate? Yes.
that's just what it is. He would flat out, that's what it is. There's no discussion of it.
I'm gonna, Ms. Allison's going to hand you what's been marked Exhibit 2. That's got a front and back page. Do you recognize what that is?
Once again, this was just another one of his changes in names, because now we're Misty Waterworks. And basically saying that our fees were increasing.
Okay, and when did you get those letters?
Somewhere right around the date that's on the top,
Okay.
that's generally pretty close to it. So,
Okay,
I can't remember the exact date, though.
That's okay. And so the letter that has the Outlaws Corral, that's the first page. First of all, is that the business that you were just referring to?
So I think you have it backwards. The Misty Waterworks, that's dated June of '21, would be the first one. Then he changed the name to the Outlaw Corral, which is then dated December '21. So we've already made
Sorry, you're
from
right.
Misty Waterworks to, yeah, so, yes.
Okay. Yeah, okay, sorry.
It's tough to keep them straight, so.
And so I had asked you if that Outlaws Corral, is that the business that you were just referring to that you'd stop at?
Yeah, that's the address of it. Yep.
Okay. And the customer letter with the Waterworks letterhead, I guess what should have been the first page, going by the date anyway. What were the circumstances behind getting those letters?
Same thing, you'd either get them thrown in your mailbox, or they'd hand them to you at the door,
Okay.
and that would be it. There's one key thing out of that letter that we really started to raise alarm bells for all of us.
What is that?
The third block on that page. It's our intention to provide improved water service maintenance and upkeep and operating equipment, overall policy and management. There was no maintenance ever done. If the system went out, we didn't have water, yes, then something would be done. Maintenance, never.
And just a note for the record, this letter was attached to the complaint that was filed in this case as attachment A. Now, on the, that Misty Waterworks letter, it says there in the second paragraph that the last sentence, you're requested to look over the provided agreement attached. Did you ever get such an agreement?
No, we have never, nope. That is this is the type of documents we would get from Mr. Blevins.
Okay.
There was no agreements ever attached for nothing.
Okay.
I will say one exception to that. And we'll, in regards to him forming his utility HOA.
Okay. But other than that, with regard to the rates and when you were receiving water service from him,
There was never an agreement.
Okay. All right, I ask that Exhibit 2 be entered into evidence.
Any objection to admitting Exhibit 2, the Outlaws Corral letter, into the hearing record?
No objection.
Exhibit 2 will be admitted into the hearing record.
And you said you received other letters like those regarding your water bill?
Yes. Frequently, I know I've submitted several of them to the PSC in the complaint.
All right, Ms. Aslin's going to hand you what's been marked Exhibit 3.
Thank you.
I believe there are 5 letters or notices included in that exhibit. Do you recognize that, what those are?
Yes.
And can you tell the commission what they are?
Well, the first one, again, was where the titles changed again for the water provider with Mr. Blevins. It's changed again. The second letter that's on there is another one of the rate
That's the same one.
adjustment letters. The third one is when the DNR became involved in it, and He states in here that because he has an operator and things like that, that fees are gonna go up on us again. So,
That's basically what the other two letters are as well.
yep, he says that, on the bottom of that outlaw corral, $1,000 per month for the public water system to operate under. Well, he had 4 wells in Misty Mountain. I'm on 1. You're telling me it's $1,000 a month? Operator does not cost $1,000 a month, I know, with our HOA.
Okay.
So, yes, that's what all of those are.
Was there anything that stood out to you or that concerned you about these letters?
It was the constant name change, trying to hide something. What's going on? Why, if you have something going on, you don't expect a business to continually change names, nonstop. And with the continual increase in rate, with the lack of maintenance. I mean, I submitted photos as well to the PSC in regards to the debris in the well house. Constantly having to go over to the well house to put the heater over there so things didn't freeze in the winter. At least 2-3 times every year in the winter when it got cold. I'd have to go over and make sure things were good. Put my tube heater in there. So there was no maintenance.
Okay. And you said you paid, you were paying a year to 6 months in advance. Do you know if he offered that to other people that were on the system?
Yeah, he'd offer the same thing. Hey, I'll give you a discounted rate if you pay me a year in advance. That's what he would do. The biggest thing for me was the convenience because you couldn't put it in his mailbox. And until that letter, now he gives you a P.O. box that you can mail it to. But we had problems because if you put something in his mailbox or if you mail him something, he may not get it because somebody stole it.
Okay.
I mean, it's just like getting texts and phone calls. Hey, pay me on this app. A granddaughter, pay me on this app for your water bill instead of taking a check to Travis. No, I'm not paying you on an app. And come to find out, Travis and I had a conversation about that. And she was stealing money from him. He told me.
Okay, so when did that happen?
That happened in November of '23.
And so how did you find, can you explain that?
Oh, I can explain that, yeah. So my neighbor was complaining that Travis kept saying that things got taken out of his mailbox. And she had to keep making out checks. And she was asking me how I do it and things like that. And I said, I just take it to him so I don't have that problem anymore. Well, then in November, I got a phone call and a voicemail from his granddaughter requesting that I pay through Cash App or PayPal or something like that instead of paying by check, and wanted me to send it electronically to her. And I had a conversation with Travis right in his front porch.
Okay.
And I said, Travis, what's going on with this? I said, I'm not doing this. I do not trust her. No, I'm not. He says, don't do it. She's already got into my bank account and stole money from me. That's what she's trying to do.
Okay, and you know if other homeowners received similar letters to these that are in Exhibit 3?
Oh, absolutely.
How do you know that?
Without a doubt, because I've seen how many of them, the neighbors have reached out to me. We've had discussions about the letters. They've been sent to the PSC. We've had numerous conversations as a community. All of us as users, especially with forming our HOA, that these are the types of letters that all of us received.
Okay. I ask that Exhibit 3 be entered into evidence.
Any objections to admitting Exhibit 3, the Misty Waterworks letters to Mr. Grube, onto the hearing record?
No objection.
Exhibit 3 is admitted onto the hearing record.
Do you know who owned the well that your water was coming from? Did you ever find out?
Yeah, we found out in January of this year, because we always assumed that it was, originally we thought it was Jim Parsons owned it. well, and then we were told that Travis owned it. That's what we assumed until January of this year, when we started discussing in regards to this HOA that Travis was forming, that we had to buy into if we wanted water supply.
Okay, and I'll get into that I'll ask you some questions about that a little later.
Yeah.
So
I
that's-
understand it's easy to accidentally slip and do that.
And what did you find out about the ownership of that well?
That well has always been owned by that property owner of that home. That homeowner has always been paying the taxes on that well. There was a service agreement that was signed with Don Baker and the previous owner of that property to provide water, which expired in 2014. So Travis never had any ownership of that well.
And I think you said that the problems with the water service started about the time that Mr. Blevins took over the water supply? Do you know when that was?
I don't think it started right away in 2016. I think that we started seeing the things in later 17 and 18. Especially in 19 is when we had the significant struggles. Do you want me to elaborate on those?
Sure, go ahead. I'll save you some
Okay.
questions.
So in July 2019, the Taylor well that Travis Blevins was operating failed. At that time, the reason that I knew that occurred is because we lost water in July, and I'm like, what's going on? I couldn't get a hold of Travis on the phone, and it's the middle of July. So I went over to the well house, and I'm like, well, why is the water shut off? Well, I turned the water on. And then Mr. Blevins called me and told me, you got to turn it back off because I'm trying to fix the Taylor well because it's broke. I'm tying the two together.
Okay.
So Taylor well went down and failed, the pump did, in July of 2019 when Mr. Blevins was operating it. He tied it into the Tigger well, which is our Tigger 1, the large Tigger well. Our Tigger well failed then in August of 2019. Flynn came out, the well provider came out, the company did, pulled our pump, placed another pump back down in. We were still connected to Taylor. Then they cut a hole in the roof again, pulled that pump about a week later because we were out without water for about 3-4 days, dropped a new pump down in. It was good. From then, we had water supply. We were providing Taylor water well since July 2019 all the way up until 2 weeks ago. Our well was. The problems were the trash that was left, the hole in the roof that was never fixed. I gave Travis the metal to replace the roof on the Tigger well twice.
And what happened?
Green metal, never fixed it. My neighbor also gave him metal to repair the roof. It was never fixed. It finally got repaired September 14th of 23. A piece of metal was put over the top as well as cleaning out the well house.
And do you know who did that?
Travis's grandson.
And at some point, you contacted the Public Service Commission, right?
Absolutely, yes, I did that in 2020. That was my initial contact,
Okay.
was the fall of 2020.
No, and did you file a complaint then also in May or sometime in 2022? Is that when you?
Yes, in 2022 is when I went to a training and I found out the phone number and name of the director for the PSC at this training. So that was my next call. And then I filed another complaint
Okay.
because something had to change.
Okay, so what happened in 2020 when you contacted the PSC? Do you
I
know what that
rec-
was about?
I received, that, I think I did that one online, if I remember right, when I filed that, I sent the email in. And I know that Kurt talked about it at the town hall when we had that then they had a kind of a changing of the guard of director and stuff kind of got missed a little bit.
Okay, that was, you're referring to Kurt Gately?
Yeah.
Okay.
Yep. He
And,
can speak to that more, what happened between that time frame. So,
right. And so so it was really in 2022 that you started dealing with the PSC? Okay,
yes, ma'am.
And who did you primarily deal with at the PSC?
Adam was the main one that I went to. Kurt, I talked to a couple times.
Okay, and that's, I'm sorry, is that Adam Stamp?
Yes.
Okay.
Yes.
May I interrupt, please? I'm sorry.
Yes, Mr. Blevins.
I've got an urgent requirement with the restroom.
Why don't we take about a 10-minute recess? It's a good time to take one anyway. So why don't we come back at 10:35? 10:35, we're back from recess. Ms. Curry, you can continue your questioning.
Thank you. Okay, so I think we were starting to talk about when you contacted the PSC. Okay. And I think you had said you primarily dealt with Adam Stamp and Kurt Gately?
Yes, that's correct. Adam Stamp was the primary.
Okay.
Like I said, Kurt, I just talked to just a couple times.
And what kind of contact have you had with Adam and the PSC since then?
Quite a bit of routine contact with Mr. Adam Stamp in regards to updates, making him aware of different situations that have occurred. Do we want to get into what we've done over the last 4 months yet, or do we
I'll
want
get into that.
Okay.
And you say routine contact, what do you mean by that?
Through phone calls, email, those were the main. Just about things that were going on, what's going on with the case. We're really getting frustrated as users, as receivers of the water.
Okay.
What's kind of the update? And then we would provide updates to Mr. Stamp and to the PSC from our experience and our side.
And about how often would that happen?
I'd say before the first of this year, probably, every other month? Every month, something like that? I'd have to go back to look to be sure, but I'd say about every 45 days.
Okay. And since January, I guess?
Since January, it's been almost weekly.
Okay. And what changed in January?
Once we found out that Mr. Blevins had no ownership of our Tigger well, and the 9 households, there were 10, because Mr. Blevins was attached to it, but when the 9 households that are serviced by that well agreed to form our own mutual HOA, not a utility HOA, a mutual HOA, then there were issues identified, so there was closer communication with both Jackie Johnson with the DNR and with Adam Stamp with the PSC related to what we were doing with the HOA being formed.
Okay. And the PSC held a public information meeting in June of '23 in Waynesville,
Yes,
Missouri. Did you go to that? Did you attend that?
Yes.
And how did you find out about it?
We received a letter in the mail, a notification of it.
From,
The
I mean, was
state
it from the PSC?
of- it was from the state of Missouri. I believe it was the
Okay.
PSC that it came from. I'd have to reference it for sure, but I'm pretty sure that that came from the PSC.
Okay. And what was your, did you have a reaction and when you received that notice? What was it?
We're like, finally, somebody's gonna do something. Somebody's looking into something. Somebody wants to find some information out to resolve the issues. Because really, we felt like nothing was being done.
And you attended the meeting?
Yes.
Okay. And do you know about how many other homeowners attended?
Oh, there was approximately, 100 people? It filled the auditorium. There was standing room only.
Okay.
So there was at least 100, I'd say.
Okay, and do you remember, was it at the, where was it?
It was at the Waynesville, what do they call it? I think it's the Waynesville Municipal or the,
Was it their government building, basically?
yes,
Okay.
yeah, it's one of them. They have 2 separate ones.
Okay,
So that one's really kind of the Public Works building, and that's the one that was in.
okay. Was Mr. Blevins there?
Yes,
Did you talk to him at all when you were there?
no. The intention and purpose of the meeting was to give the DNR and the PSC information.
Okay.
I didn't have any conversation with Mr. Blevins that day.
Okay. And do you remember what his demeanor was during the meeting? Or did you pay attention?
Yeah, I paid attention. I'm probably a good word for it would be it was tense that night at that meeting for sure. I took it as it was almost standing on your back heels, Mr. Blevins was, that he's done everything that he could. He's doing everything that he can. He doesn't even know why this meeting's occurring.
And can you just tell me about that meeting or tell the commissioners about that meeting?
It was pretty, like I said, it was pretty tense that night. There were some heated conversations that went on. A lot of conversations went on because of the inconsistencies in his billing practices and communication. We were sitting next to other providers of Mr. Blevins' water utility, that were paying $20 a month, $25 a month. And here we're paying $45, $50 a month for water. So there was a lot of heated conversations that went on that night, a lot of frustration. That's why I say it was quite tense in the room that night.
And do you think the PSC got, what kind of information do you think, would you say the PSC got from the homeowners?
I think there was a lot of individuals there, homeowners, that were finally able to voice their frustrations to someone. So I think that they got good information, but I think that they kind of got more than what they anticipated for information.
What do you mean by that?
There was a lot thrown out. A lot of information thrown out. Like the name change information was thrown out, and I don't even think that they were aware of that. I mean, that's my opinion on it, so you'd have to ask them. But I think that there was a lot more information that they gathered that night than what they even expected to gather.
And what do you mean by that? What kind of information?
His billing practices, his threats to shut off water, lack of maintenance, the constant name changes, the people that he has work for him that are family. Wow, there was a lot of topics that night. Yeah, there was a lot. So I think that the PSC got more than what they expected when they came down. That it was a bigger problem than what they even realized.
Okay, and was DNR there as well?
I believe Jackie was there, if I remember right.
That's Jackie Johnson?
Yes, I
Okay.
believe so.
Did you have any conversations with her? Okay.
No, not that night, no.
And did you talk to Adam, Mr. Stamp, while you were there that night?
Yeah, I talked to Adam, and then I talked to one other, from the PSC, I can't remember his name. One other representative from the PSC that had came out to our house before.
Okay,
You'd have to ask Adam who he brought with that day. I don't remember who that was.
okay. Now, do you think anything was done, I'll strike that. So turning to January and February of this year, of 2024, you've referred to an HOA that you and your neighbors formed for the purpose of serving your homes with water service rather than Mr. Blevins. Is that right?
Correct.
Okay. And before you formed your HOA or homeowners association, first of all, what does that have a name?
Our
Yes.
homeowners association that all of us formed on the
Yes.
Tigger Well, yes. We call it Tigger Water Well HOA.
Okay. All right. And now, before you formed your homeowners association, did you know that Mr. Blevins tried to form his own HOAs?
Yes, absolutely.
And how did you find out about that? How do you know that?
We received a letter that was once again stuck on the front door. Actually, it was on the step of the front door. It wasn't even a knock. It was just come up and toss it on our front step by our door. And that's how we were informed of it.
Ms. Aslan's going to hand you what's been marked, where are we, 4? Exhibit number 4. Do you recognize what that is?
Yes.
And what is it?
Once again, this was just communication to the PSC about what we were receiving from Mr. Travis Blevins.
Okay,
This,
I'm sorry. Go
this
ahead.
was, the first notification was that October 23rd, which is the third page of the HOA requirements for us to join.
Okay, and the last two pages, or the last two or three pages of the, that exhibit, are those the letters that you included in the email you sent, Mr. Stamp?
Yes, ma'am.
It's just easier to read.
Yeah.
Okay,
I didn't mean to send them in picture form instead of attaching them.
that's okay. So, why did you, I guess, what was the reason for sending it to Mr. Stamp?
Because there were conversations going on already amongst myself and my neighbors that are serviced off the Tigger well in regards to ownership. In Pulaski County, we have a GIF system, a GIS mapping system. We could not identify that Travis owned that well. We had already had conversations prior to the receivership case that occurred. Does Travis really own this well? So that's why I sent these to Adam so that he was aware that this is what's going on. To me, you can't form an HOA and tell someone, you must give me this money and then you must still pay me this every month. That's not the way an HOA works, in my opinion. So that's why I kind of sent these to Adam so that the PSC was just kind of aware. And then that's when I had a conversation with Travis the last weekend in November related to these. And this is when I started to get on the phone with the Attorney General's office in Missouri.
Okay, I want to focus on the attached letters, and if it's probably easier just to go to the last couple pages than try to
Yep.
try to read what was pictured. These came from Mr. Blevins?
Yes.
Both of them come from Mr. Blevins?
Yes.
And do you know who all got these letters?
Almost every one of my neighbors I know got it because right away we were texting back and forth, calls, what's going on? What is this? And then in November after the hearing, then, even around that time frame, I had a few neighbors calling me, what are you doing? Are you gonna join or what's your plans? They would ask.
And did it cause you to do anything, take any action?
So the first thing, I'm one of them very outright, straight, honest. I went right to Mr. Blevins the last weekend in November, and I'm like, what is the deal with this? Because by this, you want me to pay you $3,000. You're going to form an HOA, but yet I still have to pay you. So who's all over this? What's going on? And he's like, well, yeah, that's just the way it's going to work. So I said, you want us to pay you $3,000 per household, $27,000 for a well, and you're going to leave us with $0. What happens if the pump goes down? Oh, it won't. It won't. Well, I said the well has been there for 4 years, servicing 15 connections, with Taylor's well still being down. So you're going to leave us with nothing. He says, yeah, that's just the way it's going to be. You have to either join it or you won't have water. That is when I chose to take the action to call the Attorney General's office.
Okay, and what happened there?
They told me, and this was not legal advice, but they told me that the homeowners association that Mr. Blevins registered with the state was a utility single owner HOA, which meant he was still the controlling. The Attorney General's office stated it needed to be a mutual HOA because it's a mutual benefit to all users. The Attorney General's office said you do not have to join that HOA. He cannot turn off your water because you do not join that HOA. Right away, we shared that information out with everyone else on Misty Mountain, that he cannot force us to do this.
Okay, that was in your in your subdivision?
Yes.
Okay. Do you know if anyone accepted the offer, Mr. Blevins, set forth in these two letters?
No one that I'm aware of on the Taylor well or the Tigger well. No one joined the HOA. I know that there was discussion on some of the other systems, but I mean, that's just conversations that they were. But they were being told the same thing, I know, over on Charity and Rolling Hills, because they were even reaching out to us for help on what we were doing because they heard what we were doing with Tigger.
So you said, okay, first I'll ask to admit these Exhibit 4 into evidence.
And what would you like to call this exhibit?
Um,
How about HOA letter?
HOA letter, sure, or letters.
Is there any objection to admitting Exhibit 4, the HOA letters, onto the hearing record?
No objection.
Okay. I have one question for you, Mr. Grube. On the last page of the letter at the top, it looks like there's some notes that were taken in handwriting. Are those yours?
Those are my notes.
Okay,
From
so
my
it
phone
didn't
calls.
come like that?
No, those are my notes on that letter from phone calls and dates that I had.
Exhibit 4 is admitted onto the hearing record. Go ahead.
Thank you. And you said you discussed those letters with Mr. Blevins?
Yes, ma'am.
And where did you discuss them with him?
That was the last weekend in November when I was making our December water payment to him on his front porch of his house. During that conversation, I made my payment to him, like I always do, handed him the check. And then I asked him about the HOA, and he verbalized to me that, yes, you have to join the HOA. This is what we're going to do. Yes, I'm taking the $3,000 that everyone gives me, and that's you purchasing the well, but I'm still going to manage the HOA, and you're still going to pay me. At that time, because of the other discussions that we had going on, and some other neighbors asked me, will you see if he really owns it? I told Travis flat out, I said, we don't think you own it. So you're trying to sell us something that you don't even own. So I said, I need proof before I will even consider this or talk to anyone else that you own it. So I said, I'll give you 2 weeks to give me some kind of ownership documents.
Okay, that was,
That was the last weekend in November of '23.
and you're talking about the well that serviced you, the
Correct.
Okay.
The big Tigger.
big, okay.
Tigger 1, I think the DNR called it, if I remember right.
Okay. And did Mr. Blevins give you that documentation that you asked for?
Nope, I asked for it again around the 21st of December, and to this day, never seen nothing.
Okay. Did you ever find out
Yes,
on
we did.
that well?
Yep,
And what did you find out?
that's where we found out that the neighbor, the one that the well is sitting on, is the actual owner of that well.
And does Mr. Blevins have any ownership interest in there that you
No.
could find?
No, the last service agreement that was done was with the previous owner of that property and with Mr. Jim Parsons, who owned that well originally. There was a service agreement attached to the deed investigation and audit. But once the current owner bought that property, that was null and void. So no, there was no ownership of Mr. Travis Blevins to that well, no service agreement for that well from the owner of that well or anything.
Okay, and you said, you just mentioned something about a title audit.
Yes.
What do you, Can you explain that? What,
So in order for us to make sure that we were in the free and clear after the conversation with Attorney General, he said I would really just go ask for that first, start there. If he doesn't have any ownership, then he doesn't have any rights to it. So that is where we went to then. Asked our neighbor, since he's the one that owns the property, to go down to the county assessor's office and request a deed investigation audit back to figure out whether Mr. Blevins had any ownership rights to that well at all. So that was requested then.
okay,
We
and,
received that back, and that's where that stated in there that yes, there was a part of an easement that was started, never finished though.
okay.
And that homeowner is the one that has paid property taxes on that well ever since 2014 when he moved in.
Did Mr. Blevins ever give you a reason why he didn't have those documents?
Nope, he just said he couldn't find them.
Okay.
He said he had them. He owned it. He also made a couple statements that, it was an agreement. Well, I said an agreement does not work when it comes to real estate.
Okay,
And he told me that he used to do real estate, and he says he's not dumb. He knows that it does. So he knows he owns it. I said, no, you don't. Not unless you can produce a document that shows me that.
can he never produce that document?
Never produced any document.
And so you never, you did not join the HOA,
No,
pay the $3,000?
negative. None of us did that are on the Tigger well currently. Not one of us.
Okay.
Nor did any of the Taylor residents.
And the Taylor residents, those are the ones on the Taylor well?
They were the ones that have been serviced by the Tigger well, our HOA's well, since July of 2019 up until June 6th of this year.
Okay,
That's how I know about them, because they were very cooperative, they were understanding with us forming the HOA and everything. So they know as much as anyone in our HOA does.
okay, so there's your HOA that has the Tigger well, and then you said there's the Taylor residents, they're the ones that were connected to your well, the Tigger well?
Correct, because we were just providing them water. They were not part of our HOA. The Tigger Water Well HOA is just the Tigger Water Well recipients, the connections, the 9 connections, that's it.
Okay, and the people that lived on Taylor, they were customers of Mr. Blevins?
They were, yes, they've been customers of Mr. Blevins.
Okay, do you know how long?
I'm going to assume since 2016. I know it's since at least 2019.
Okay. So what steps did you take to form your homeowners association?
So really, to form it, we got that audit back. We met prior to that just with discussions. The 9 homes, there were originally 10 homes that are primary connections to the Tigger well. Mr. Blevins was one of those. The other 9, there were some pain points. Multiple homes did not want to meet because Mr. Blevins only wanted his HOA. He wanted to run the HOA. He wanted us to buy it from him. So many of them would not even meet if he was at the meetings. So out of the 10 connections, the other 9 of us all met, had conversations and discussions about forming a mutual HOA. All 9 other homes agreed and signed into an agreement with the HOA to form the HOA, is what they did. We elected our board, which has a president, a vice president, and the secretary, treasurer. We formed that. We wrote up service agreements. We took and notified Mr. Blevins of this, gave him the opportunity to complete a service agreement within 10 days. Or have an alternative source of water. Mr. Blevins made the decision to disconnect from the big Tigger 1, which was our well, and connect to the Tigger 2 well across the road from him. So now there is 9 members of that HOA that have active connections
Okay.
and are members of our HOA.
Okay, Ms. Aslin's gonna hand you what's been marked Exhibit 5. You said you had let Mr. Blevins know about forming the HOA and all that. Is that letter, those letters that I've provided you, is that notice? Is that the notice that you were talking about?
Correct.
And who are they addressed to?
This was provided to this is the letter here that went to all the Tigger residents that have direct connections to the Tigger 1.
Okay, that's the first letter?
This also went to Mr. Blevins, as well as that back page, the second page of it as well.
Or the one that's dated March 4th, 2024?
Yep. This is where we gave him notice that he had 90 days also, up until the 2nd of June of this year, to have that Taylor well up and running, that went out of service in July of 2019. We gave him that notice. Also, we informed him that those Taylor residents were no longer going to be paying him their water service when we're providing the water service to them.
Okay,
This also informed him that there was prepayments that are documented from Tigger well connections to two addresses. I won't include names. 2 addresses there, and that's where this also says that he owes us $1,155 in prepayments that he had received because we were not going to charge the residents on top of what they'd already gave him for prepayments.
I suppose, before I forget, we should probably mark this one confidential since it has those other addresses on it. Or does it just have, no, yeah, it does.
The back page has.
Yeah, it does have those addresses.
Yep.
And you said you obviously you sent this to Mr. Blevins. On that,
This was hand delivered to Mr. Blevins
okay.
because I had to read it.
What do you mean you had to read it?
He said when we were standing on his front porch, my neighbor and I, so we had 2 of our board members that went to Mr. Blevins to deliver these letters to him. He snatched all of them out of my hand. I took them back and I said, "Here's your copy, here's our copy." And he said he couldn't read it. I said, "Well, would you like me to read it to you, sir?" He said, "Yeah." So I read the whole thing to him. He refused to sign it and got very irate.
Okay, did he tell you why he refused to sign it?
Because he says I own that well.
That he owns that well?
Yep, he said he was going to call the sheriff. I said, "Okay, go ahead and call the sheriff. We have all the deed paperwork." His wife came out and got mad yelling at us, and I said, "We're done." We walked back to the vehicle and left.
Okay,
They were going to call the sheriff. The sheriff never showed up at my house.
okay. I'd like to offer Exhibit 5 into evidence, ask that Exhibit 5 be entered into evidence, I'm sorry.
Mr. Blevins, do you have any objection to admitting Exhibit 5, the Tigger Well HOA letter, onto the hearing record?
No objection.
Okay. Exhibit 5, the Tigger Water Well HOA letter is admitted onto the hearing record, and that is a confidential exhibit. You may continue, Ms. Kerr.
Thank you. Just trying to figure out where I am on in my questions. So is the Tigger well, which is part of your HOA, which is the HOA that you have, is that certified or regulated by DNR?
It was, and we went into it knowing that it was going to, because part of the process of that, and we were well aware of it, with talking with Jackie, and mapping out the service connections that between Tigger and providing water to Taylor, the 5 houses, that it was gonna be regulated because it had 15 connections, which didn't matter, but we were over the 25.
Okay,
So we knew it was gonna be regulated without a doubt. So we were working with the DNR to make sure that we were in compliance with that. And that's why we were also then in March working to find an operator, and that's why we contacted Lori Jean. So we knew it was gonna be regulated. We wanted to work with the DNR to ensure that we were in compliance.
okay.
And we knew it was gonna be a non-compliant well, just because of the stipulations and things like that. So we were very aware.
Okay. And so it was considered then to be a public water system by DNR? Do you know?
I don't know if it was considered a public water system. I know it was a regulated.
Okay, that's
That's
fine.
what you'll have to ask DNR on that exact language.
Okay, that's fine. Did you have a certified operator then once it became designated or regulated by DNR?
Yes, in March, was it March or April? Oh. I gotta look to make sure.
Sometime in the spring.
Yeah, it was March or April. I know that we had conversations with Miss Lori Jean in March. I don't remember what the exact day was.
Okay.
That we went into the agreement with her. She was willing to work with us. She knew the situation. She gave us recommendations right that day, and we started doing those.
Okay, what kind of recommendations?
Well, the biggest thing was is make sure and get the sign hung on the door. She stated to me on the phone that I've asked Travis to hang the sign on the door how many times, that no one else can be in the well house, and it hasn't been done. And I said, well, what kind of sign do we need to meet law? And she said, well, just this one. And I said, okay, no problem, I'll order it. So we did.
Okay, what kind of sign was it?
It's a sign that basically says it's against no trespassing. It's federal regulation or federal law that prohibits anyone from entering the property because it's a well house.
Okay.
So we did that right away. We did everything with Jackie that we could in order to make sure that we were in compliance there. We started having discussions about the DNR in Dalton coming down and doing the survey or inspection, as well as water testing and things like that. So we started the paperwork like we were supposed to.
Okay, and that's Dalton Young from DNR? Is
Yes.
that who you're referring to?
Yes.
Okay.
Yep.
Now, Lori Jean, she's the same certified operator that Mr. Blevins had
She
previously?
was, yes.
And she seemed to be responsive and know what she was
Yeah.
doing?
Yep. I got more information out of her whenever she came to do water testing when she was operator for Mr. Blevins than when I ever got out of Mr. Blevins. I never received a water test out of Mr. Blevins ever, even when I inquired. And Miss Laura Jean was just like, well, here, go right here to this website. You can see exactly every water test.
Okay.
So she was very responsive, especially with us setting up the HOA and making sure we were in compliance and things like that.
Okay, is she still the certified operator?
We do not have to have a certified operator now since Taylor was disconnected. And Travis got Taylor well up and running on the 6th of June because we had a shut-off notice for that for the 3rd of June, which he did not meet. And we can go into that probably a little further here later. But yeah, no. Now, just to summarize it, no, we are not a regulated water system, a regulated well now, although we're still doing water testing and
Okay. So you're not regulated by DNR?
Correct.
And so you don't have to have a certified operator?
yes, ma'am.
Okay. So you might have testified to this before, but why was your HOA serving houses that were not part of the HOA?
All we know is that in July 2019, that Taylor pump broke. The pump was bad. That's all we could find out. The well house over there on Taylor was absolutely horrible. I mean, I can't believe it was still halfway standing at least. So you knew that there was issues there. But the pump failed in July of 19. It was pulled out, the pipe sat on the ground, covered with a tarp for years.
Okay, so was it, and that's the Taylor
Yes,
folks. Was it your HOA's responsibility to take care that the Taylor Lane residents had water service?
the only thing that we were responsible for with the Tigger Well HOA was to ensure that they had water provided to their lines. The maintenance of their lines was still up to Mr. Blevins.
Okay. And so, but since they weren't part of your HOA, did you feel like you had any responsibility to service or to provide water to them?
Yeah, because even after having conversations with multiple state representatives, whether it be the Attorney General's office, they were like, "Well, just cut them off. It's Travis's fault. It's his problem. You don't have to provide them water." Yeah, we could have did that. But if I was on the receiving end of that, I would be hot. I would be absolutely livid. So that's why we decided, let's give them 90 days. 90 days is more than enough to drop a pump down a well.
Okay.
So that's why we were fully transparent with them what was going on. We're going to provide your water up until this day. We let them know what was occurring, kept them in the loop. So they were all in agreement and supportive of it as well.
And you said you gave them a deadline, 90 days?
Correct. It was June 2nd.
Okay.
90 days exactly from the day that Travis received the letter on March 4th.
Okay, is that the notice is that a notice that you gave Mr. Blevins?
Yes.
Okay. And do you know what his reaction was, or what his, to that letter?
He didn't care. He just said, okay.
Okay. Did he make any promises to fix it or to take care of the Taylor?
No, there was multiple times because I wanted to, I'm not gonna be selfish. I wanted to make sure they had water over there.
Okay.
There's families, there's kids. So there was multiple times that I would stop and talk to him and be like, "Travis, what's the deal? Is it gonna be fixed? Are they gonna have water? We can't keep doing this." And every time he just got irate, mad, that Tigger was his well and he's gonna take care of the problem. And I said, "Well, it'd help if you would communicate with us somewhat." And there was no communication between Mr. Blevins and the HOA at all in regards to it. I mean, we served him that letter I went around and did all the mapping of all the water lines, all the services and things like that. On March 19th, 18th and 19th, I ran every single line so that I knew exactly where all the shutoffs were, all the connections, all the lines ran and everything. I identified a leak. We made Mr. Blevins aware. To this day, until it was disconnected at least from Tigger, that water leak has not been fixed. So he didn't want to communicate with us with anything.
And that water leak was on the Taylor folks?
Yes, ma'am.
Taylor, okay.
Ultimately, we can go into that later.
Go ahead.
We served him that letter after we found that on March 20th, and let him know that needed to be fixed within 3 days. It sat for weeks. Then we had the storm on the 1st of April, still wasn't fixed. Then he dug a hole down there about, I'd have to look at what day was that? It was the middle of April that he dug a hole down there. No, it wouldn't have been the middle of April, because Mr. Stamp came out on April 25th to take pictures, to file a report about how bad the Taylor well and that leak was. So May 5th We served him the letter on March 20th. May 5th, he chose to finally go down there with a backhoe and dig a hole in that resident's yard, then filled that hole back in, and then dug a hole about 8 to 10 feet around where that leak was, that's about 4 feet deep, and let it sit there. Then he'd come back a week later and dig a trench so the water would drain. Ultimately, he never fixed the leak. That resident, that property owner, ultimately gave him a deadline of May 31st to have that repair completed and that hole filled in, or they were gonna fill that hole in themselves with their tractor. He never fixed it. They ultimately filled the hole in with the dirt.
Okay. And finally, this last exhibit, Ms. Allen's going to hand you what's been marked Exhibit 6. And do you recognize those documents?
Yes, this is everything that we served to Travis and his wife in regards to this about the water being shut off. This one was served, both, we gave it to him, and it was sent to him by certified mail that he had to sign into the agreement, or 10 days, the water would be turned off. And that's where our agreement was signed by both the HOA and the resident. And it was very clearly outlined in our service agreement, whose responsibilities what, when things are due, what occurs. So then the second one is the leak. Like I said, March 20th, that it needed to be repaired within 3 days. The second one there, it'd be the third one then. That is the one that we delivered to the Taylor residents, letting them know, hey, we identified this leak. Jackie was also informed at the DNR, probably didn't need to, but hey, new to this, we're gonna make sure and communicate. So called and talked to Jackie, let her know. She said we had to do pressure testing. I went and got a pressure gauge, went over and tested it, and all of them were greater than 55 PSI, so we let the residents know that as well.
Okay.
What's the next one? May 21st, this is the one where we said that Taylor well must be operational by June 2nd. He still had started no work on it at all. He did not answer the door this day, so this one here was delivered by 2 of the Tigger Well HOA board members, and it was stuck in his door.
Because that's what that note says left on Travis's
Correct.
door. Okay.
Yep, because he would not answer the door, he would not talk to us. So that was served to him, as well as the Taylor residents also received notification that the Taylor well would be shut off on June 5th. So that they were aware as well. Now, that wasn't the end of it, because we didn't want to just shut something off. I knew that Rick's Pump Service was doing the work, although Travis owes him over $20,000 in unpaid debt, that I knew Rick was going to be the one that was going to do the work on that well.
On the Taylor well?
Correct.
Okay.
Because Rick had been the one that'd been working on the topo well. So I called Rick and I'm like, Rick, here's the situation. Since Travis didn't want to talk to us, I called Rick and I let Rick know what was going on. And he's like, yeah, Travis told me this. He's like, I'm planning on getting out there on Monday on the 3rd.
June 3rd.
Yes. And he told me, well, we're going to do it on the 2nd. We're going to pull the pump out of topo. So I said, okay, you're going to pull the pump out of topo. He says, yes, so that we can put that pump in Taylor. I said, okay. So you're going to have this up and running for these residents before the 5th of June. He said, I'm going to try my best. I'm doing this for nothing because I'm not going to get paid for this.
Okay. And was he doing that at the request, at your request or at
No, he was
Mr.
doing
Blevins'?
this at Mr. Blevins' request. That's what Rick told me, though, because I wanted to make sure the Taylor residents had water. There's kids. There's families. And I didn't want them to have to go down to the Big Piney to go take a bath. That's just wrong. So I was trying to make sure, since Mr. Blevins didn't want to talk with us as an HOA to keep us informed, at least I had something, because the Taylor residents wanted to know if it was gonna be fixed. The Taylor residents were provided Mr. Blevins' contact, Mr. Adam Stamp's contact, as well as Miss Jackie Johnson's contact and the Attorney General's contact information when they received that shut-off notice, that it was gonna be shut off. And I said, I can't do anything else. You guys have gotta put pressure on him
Okay.
to get it done. So ultimately, they did. They pulled the pump on the 2nd of June. Rick called and informed me of that. June 3rd, Rick called and informed the other board member that the pump had been placed. They had chlorinated the system, dumping bleach in it, and then they were gonna come back the next morning and take a water sample, but they didn't know when it was gonna be turned on.
And was that up to Mr. Blevins to do that?
Yeah.
Okay.
He knew the shut-off date was supposed to be the June 3rd. We were being nice, and we went to the 5th. And ultimately, at the request of Rick, when he called the other board member and said, hey, can you give us some time? We're waiting on the water test to get back. We said, we'll give you till the 6th. On the 6th, the water was shut off. The residents on Taylor then contacted Mr. Blevins, and Mr. Blevins says, well, I didn't even know the water was turned off. They were without water for about 3.5, 4 hours over on Taylor until Mr. Blevins went and turned that water on. As of last week, they still have no clue what the water test showed.
And so now since June 6th, the Tigger well and the Tigger HOA, you guys are just servicing your HOA.
Correct, yes.
And the folks on Taylor, they're being serviced by the Taylor well?
Yes, they are being serviced by their Taylor well, and according to the pressure gauge that the neighbor has right there, they're running at on a 44 to 46 PSI. So they're being serviced off their Taylor well. All the Tigger residents in the Tigger HOA, all 9 homes are being serviced by the Tigger well.
Okay. I ask that Exhibit 6 be entered into evidence.
Mr. Blevins, do you have any objection to admitting Exhibit 6, the Tigger HOA shutoff, and notice of leaks?
No objection.
Exhibit 6 is admitted onto the hearing record.
So then as of now, your well, your HOA is not serviced by Mr. Blevins?
That is correct.
And the Taylor well, are they serviced by Mr. Blevins that you know
Yes,
of?
they are serviced by Mr. Blevins.
Okay.
He is the owner of that well based on the Pulaski County records.
Okay.
And he received that well back from Mr. When he sold that well for 30 days, it was supposed to be up and running. It never got up and running. So that's why he got the well deed back. He owned that well. Well, he operated that well prior to that, I know for a fact,
Okay.
because of the incidents in July of 2019.
And what incident was that?
That was the one earlier I was talking about with when we didn't have water in 2019 when the Taylor well went down.
Okay.
He was over there fixing it, and I went over and turned the water on, and he called me and told me to turn the water back off because he had to connect the two.
Okay. I don't think I have any other questions at this point.
Thank you. Mr. Blevins, do you have any cross-examination questions you wanted to ask this witness?
I do have, but at the present time, can I reserve to recall Mr. Grube back for that particular?
Why would we need to do that?
My medical condition, sir, I need to take another rest. I'm sorry,
No, that's okay. How long of a break do you need?
just a few minutes.
Okay, why don't we take about another 10-minute break and come back at 11:35?
Okay.
We will recess till 11:35. When we left off, it was Mr. Blevins' opportunity to do any cross-examination. Mr. Blevins, did you have questions you wanted to ask this witness?
I do have, yes, sir.
Please go ahead.
Okay, Mr. Grube, you indicated in all of your testimony there different things, argumentatively, I assume. But do you have evidence when you talked about, when you were given a notice of the possibility of forming an HOA from me, was there any evidence that you have that says if you didn't join this HOA, then your water would be cut off? Do you have that, or did you?
Your conversation with me
I don't
is the
recall.
only evidence because I did not record anything, Mr. Blevins.
Yeah, well, that you don't have any evidence of that. Does it say that in the letter?
Let me refer back to the letter to see if it does.
Okay.
No, it does not. It just says at the end, feel free to call you or discuss with you any questions or concerns. So that's why I brought my questions and concerns to you, and that's why we had that conversation on your porch, that was going to occur.
Okay.
But that is the only evidence that I have from our conversation related to it.
Yeah, that there's no indication that if you did not join the HOA, that your water would be cut off.
Well, that's what you told me, sitting
I
on
don't-
your front porch.
Yeah,
So
I
that's
don't-
what I'm going off of is,
Yeah, I don't want to argue with you, Mr. Grube.
No.
But, I don't particularly recall that, so we'll just go with what you said there, okay? You also indicated that that other users of the water were paying different prices. Where did you get that information from? Where did that come from?
well, first of all, we heard that in the, whatever the PSC wanted to call that June 1st evidentiary hearing or meeting with the community. That was brought up multiple times during that meeting. That there
Okay,
were
well-
varying,
What was the figures that you used then?
Mr. Blevins,
Can
don't
I-
interrupt your witness when they're answering.
Okay, sorry about that, Mr. Grube. Go
so
ahead.
during that meeting, there was multiple occasions where it was brought up about the different prices that everyone was paying. And then also with conversations as we were forming the HOA, the Tigger Waterwell HOA, there was multiple conversations that we had. And there were multiple statements made by other users on that Tigger Waterwell HOA that some were paying $35 still, some were paying $40, some were at $55. So that's where I'm taking all of those statements from.
Could that
It's
have
from
been, maybe could that have been a misunderstanding on some parts there of those people you talked to from different areas? Is that possible?
During the June meeting with the PSC in Waynesville, yes, that could be probable. In regards to the conversations as we were forming the Tigger Waterwell HOA, no, that can't be because they're all in the same water system. And they're not at discounted rates.
What are the
That is-
figures? What are the figures that was used then at the Tigger well?
One resident was only paying $35 a month. There was one resident that was paying $45 a month. And then there were the others that were paying $55 a month. One was paying $60 a month. Out of 9 connections, there was that many variances already.
Do you have evidence? Did you have evidence of that? Or is that just a rumor?
I have my conversations that I had as I was forming as a board member for the Tigger Waterwell HOA. But as for the June, those are on record with the PSC, those variances. But as you stated, those may be because they're different water systems. But with the Tigger Waterwell HOA, that's what I had as a board member those conversations about the different variances and prices. Do I have it in paper and writing? No, I do not.
Okay, all right. You mentioned about name changes, company name changes. Where did that come from? How did you determine that?
Well, Mr. Blevins, if you look at all these evidence pieces, we have Misty Waterworks. On one, we have DBA, Misty Waterworks. I'm going off of your letters, your notices. You have delivered us letters, Outlaws Corral, that you call it. And my wife and I have tried to write checks out to those different business names.
Why would you want to do that?
Because generally when you do business with someone, like when we form Tigger Waterwell HOA, no one makes their check out to Jeff Grube. They make their payment out to Tigger Waterwell HOA. If they make it out to my name as being the secretary and treasurer, I cannot deposit that because I have an account that is set up for Tigger Waterwell HOA. I've had other businesses in the past, and I've always kept business separate from professional when it comes to regulations, tax laws, and everything. So that's why if you give me something that has a business name on it, I expect that I can write a check out to that business name and not to a person.
If you were told different, wouldn't that clarify that?
After the fact, if I write a check out and then you tell me that I have to write you a check out to your name because you can't take it in the business name, that raises a couple yellow flags and red flags of what's going on.
Wouldn't you think maybe that there is no account set up with Misty Waterworks, basically, or Outlaws Corral?
In my professional opinion, I would think that you would have it set up that way. It's just like if you go to Lowe's, you don't make a check out to the store manager, you make it out to Lowe's.
Well, you're argumentative about a lot of different things, in my opinion. Do you like to do that, or correct, or?
No. I like to make the check out, though, to whoever it's going to. That's what I'm stating, sir.
Let's go back to one of these statements or notices that I sent to you, probably. Let's look at, let me find it here just a minute, yeah. I don't know, you made comments about this not receiving water bills. We never did provide a water bill.
I'm going to ask what exhibit he's referring to. I think it's Exhibit 1, but I'm not sure.
What?
Which exhibit are you referring to?
I'm looking at, I don't know what the exhibit is. It's not marked as an exhibit. It has to do with,
What's the top of the first page say?
this first page says Misty Waterworks, 1920. Okay. It's also December 10, 2018.
Okay, that's Exhibit 1.
Exhibit 1, okay.
All right, thank you.
Back here on that notice, the notice simply says that it received and posted your payment of $210 as a 6-month prepaid premium. However, the discount payment is $40 per month times 6 months is $240. There was just a notice to you, not a billing. It didn't say anything about cutting your water off. Has your water ever been cut off for non-payment?
You have never cut my water off, Mr. Blevins, for non-payment because you came to me and asked me where my shutoff valve for my house was.
You don't have one.
I do in my basement, and I said that day that you don't have to worry about me ever not paying my bill. Have I ever not paid my bill?
Oh,
never-
no.
Okay.
Yeah,
I wouldn't say that you didn't pay your
Mr.
bill,
Grube,
no.
everybody stop talking while I am, please. Mr. Grube, I appreciate you testifying, but you're not here to ask questions today. So I know you want to question Mr. Blevins, but let's refrain from doing that. It makes the whole process a little confusing.
I didn't mean to.
And Mr. Blevins, don't argue with your witness. Let your witness finish answering before you go on to your next question.
Thank you. So what is your opinion of that particular notice to you then?
That was a notice that when I made that payment of $210 for the prepayment for 6 months, but then you informed me that it was $40 a month, so I was $30 short.
Did you turn around and pay that?
I'd have to go back and look at my canceled checks, and I'm absolutely sure, without a doubt, because I've never not paid you, sir.
Yeah. The
Do you,
notices that you, what is your real opinion, though, of this notice? You made comments about it in your testimony.
Can you clarify your question? What do you mean when you ask what's his real opinion on it?
Well, you disagreed. You disagreed, apparently, with the notice. It's saying that different people pay different prices. In some of your comments, different users were paying different prices.
I'm not sure how that relates to that particular notice, Mr. Blevins.
Okay. Well, it was entered as an exhibit to his comments where I'm not sure. I'm really not sure.
Now, when you say you're not sure, you're not sure what you mean when you're asking him what his real opinion is, or you're not sure what this piece of evidence was entered in relation to?
Well, I was asking basically what his comments were and how he interpreted this notice.
Okay, well, I think that's a fair question. How did you interpret this notice, Mr. Group?
yeah, these notices we interpreted basically right as they're wrote, that our fees were going up, if you're referring to the first page of that exhibit. The other, like the second page that you're referring to, those, if anything, were just for information. Or if we were past due, those were when we got those notices.
Okay.
But that's it, in regards to them.
Okay. Did you agree with it or disagree? Did you disagree?
There were some of them that I disagreed, as I stated, like that one, on the back side of that, on 7/5 of 20, when you said that I was past due, and that was not the fact, because I had the canceled check of when that was paid.
Okay. Did you
So-
provide that?
I did not provide you the canceled check, sir. I said that I had paid, and I let you know what the check number was, but I didn't go to the bank to
Okay.
get a copy of the canceled check. You said, okay, because I remember the conversation in front of my driveway, and you said, okay, it's probably somewhere, so, okay.
Okay. All right. So apparently I agreed with you then, maybe. Is that the way you interpreted that?
Yeah. I mean, your question asked me if I disagreed with the letter that you gave me. Yes, I did.
Okay.
Did we ultimately have a conversation in front of my driveway to resolve it? Yes, and we agreed.
Then we
We were good.
resolved it? Was resolved? Okay.
Yes, we were good then.
All right. You indicated about taxes, where where your neighbor paid the taxes on the well. Are you aware that the well has never been taxed?
The well is part of the personal property tax. So it's part of the tax assessment.
No, there's
That-
two different types of taxes there, Mr. Grube. One would be personal, the other one would be real estate.
So it's as part of the deed audit, and my apologies, I used the wrong term for personal. It's the real estate tax in the county of Pulaski. The deed, it actually shows the well as being on that resident's property. So that's why I say, per the auditor and the county assessor, that homeowner is the one that has been paying the property tax on that well. And that's per the Pulaski County.
The property tax would be for the property that he owns, yes, that's correct. But it would not particularly be with the well. And would you agree that maybe that's part of the problem with Pulaski County, is the assessments?
From my experience, no. Their system that they have is pretty well in line. I can look up any piece of property wherever it is and see exactly who the owner is. I've never had any problem.
Well, I was talking about separate taxation. When you describe a piece of property, they will assess it and assign a tax to it, a value and a tax to it. The well has never been taxed, but it has been taxed on the property that your neighbor owns. The well happens to be on there, but it's not separately taxed. That's been probably some of the major problems that Pulaski County has.
Mr. Blevins, at this point, you're testifying and you're not asking a question.
Okay,
If you want to testify about it, you'll have plenty of an opportunity to do so.
Okay, I'm sorry.
But
Thank
you need to keep the questions short enough that they're
Yeah.
understandable.
Yeah.
Also, I'd
Okay.
object, Mr. Grube isn't an employee of the assessor's office. He wouldn't know how they're taxing companies.
No, he wouldn't, but he wasn't asked that question yet. He was asked what his opinion was of the taxing authority in the county.
Okay, I thought there was a question about that in that. I'm sorry.
Oh, you may, if you're right, I've missed that, but I did not catch that.
Yeah, let's see here. Well, I don't think I would have any further questions for Mr. Grube. No further questions.
Any commission questions for this witness? I hear none. I've got a few questions for you, Mr. Grube. And I'm kind of bounce around a lot of different directions. If my questions don't make sense at any reason or at any time, please let me know. Now, you indicated that Mr. Blevins was also located on the Tigger 1 system. Is that correct?
Correct.
Has his residence always been located on the Tigger 1, to the best of your knowledge?
To the best of my knowledge, since I know, yes, he was connected to the Tigger 1.
Okay. And I have no understanding of the geographic layout of this system. So how far would you say you live from Mr. Blevins?
I'd say from Mr. Blevins, I probably live 400 yards.
Okay, so you can see his house from your property?
If I walk up to the road, yes, because I live down, there's a knoll right there that it goes over the top of, so,
Okay. Are the residences there in that area pretty spaced out?
yes. Most of them are 3, 4, 5 acres.
Okay, so would your answer be similar for your other neighbors, that you live 400 or 500 yards from them?
No, like the neighbor across the street from me, I mean, we're 100 yards apart. I got a neighbor next door that her property line's probably 50 yards. I can see their houses, no problem. I can't see his house because of the knoll, the ridge that's between basically Tigger 1 well and Tigger 2 well. There's a little bit of a hump in the road just because of the contour of the ground.
How close are the Tigger 1 and Tigger 2 wells to each other?
They're probably about 200 yards.
Do you know if they're on different plats of property?
Yes, they are.
And you indicated that the Tigger 1 is on the property of someone you know?
Yes.
And you said there was an easement that had been started but not completed. Is that correct?
That is correct, sir.
What can you tell me about that?
I know that the lines have been drawn out for it, but nothing was ever put forward to separate it from that homeowner's property. And it's basically been identified with corner points, but that's it. And that was back, I'd have to look at the deed again. I don't remember what year that was done.
Well, you said that there was a servicing agreement, and that servicing agreement ceased to be when the property was sold in 2014. Is that correct?
Correct.
What makes you think that that servicing agreement ended with the sale of the property?
Because that was from the homeowner to that former well owner, and that came from that audit, from the county assessor's office.
And that service agreement was for Mr. Parsons or Baker Construction, is that correct?
Yes, it was for Mr. Parsons and Mr. Baker to provide water from that well, from that property.
And to the best of your knowledge, they continued to do so through 2016, correct?
Yes, to the best of my knowledge, from the point when I had received that notice, that Mr. Blevins had taken over that well, yes.
Did you have, and you may have covered this already, so excuse me if I'm asking questions you've already answered. You had did you have an agreement with Parsons and Baker?
For our water agreement, a signed agreement?
Yes, a contract?
No. We knew that just as homeowners up there, it was part of our deed, that we paid them for the water service.
Did you receive a monthly bill?
We received notices of our bills. We received receipt for our payments.
What do you mean a notice of bill?
Like if we were behind at all, they would send a notice. They sent you a notice that when we first purchased the home, they sent us the notice that, hey, this is the monthly bill fee. This is where you pay it.
And so you didn't receive monthly bills, but as long as you were timely, you wouldn't receive a notice either.
Correct. Yes, sir. I should have worded it that way, I guess.
No, you're fine. You're doing just fine. My questions are kind of stream of consciousness. After Blevins acquired the well, did you talk to Parsons or Baker at all about it?
That's how I initially found out, because there was a problem with the well. And that's when Mr. Parsons said that Travis had taken them over. And then it wasn't shortly after that that I received the notice.
Now, did you say at some point that your residence was receiving water from the Taylor well? Is that correct?
No. Our well was providing the Taylor residents water.
Okay, I think I knew that.
Yeah.
You had said at one point that there was a pump dropped down in, and that you let me formulate this question better. If I remember correctly, you said in 2019 that a pump was placed in one of the wells and it ran fine after that. Was that the Tigger well?
That was the Tigger well. That would have been August 2019. They cut the hole in the roof, dropped a pump down into the Tigger well. Then a week later, they had to pull that pump and put another new pump down. That is correct. That was in August of 2019.
And you said that pump came from the Topo well?
No, that was a brand new pump. It was a 5-horse variable speed from, I don't know if I can say the company that did the work. But they put a brand new pump down that one. My statement about
And it's worked since then?
yes.
The 9 houses or the 9 connections that are served by the Tigger 1 well, is there some sort of geographic similarity that makes all 9 of those appropriate for a homeowners association, but not further owners that were being fed by the Taylor well? I mean, why is the delineation drawn where it is?
Because through conversation, those 9 were the original that were connected to the Tigger well. Those are the 9 original service. Well, Mr. Blevins would have been the 10. There was originally 10 homes on that Tigger well. And then when the Taylor well went down in July of 2019, Taylor residents were connected to that Tigger well. So at some point, because of the length, we couldn't leave Taylor on ours, because you're talking pumping water almost a mile.
And that is what I need to know. Thank you.
So that's why we couldn't, yeah, that's, okay.
And you said the Taylor well was up and running on June 6th, is that correct?
Correct.
How far away is the Taylor well located from the Tigger 1 well?
I'd say probably, as a crow flies, probably a quarter mile. Somewhere between a quarter and a half a mile.
Do you know how many residents or how many connections are served by the Taylor well?
I know that there are 5 houses connected. Originally, we thought there was 4. But then I was notified by another resident that they were connected to that well approximately 4 weeks ago.
And do you know how many connections are to the Tigger 2 well?
There are 6 with Mr. Blevins connected to it now.
Now, you seemed to earlier indicate that you understood that he owned the Taylor well, is that correct?
Correct.
And how do you know he owns the Taylor well?
Through talking with the residents and through back in July and through multiple conversations that him and I have had, he offered for me to buy that well, but he wanted $9,000 for it when it was non-operational. And that would have been last summer when we had a conversation. He also offered for me to buy the Tigger well last summer, but he wanted $18,000 for that well. So that's how I know that he owned it. And plus, when I turned the water on for it, for our well, on that July of 2019, when that Taylor well went down, and I went and turned it on, that's when Mr. Blevins called me to turn it back off.
But you've never seen any documentation that he owns it, correct?
No.
And you didn't engage in any kind of title search or anything like that with Pulaski County in regard to the Taylor well, just the Tigger well, correct?
Correct. Yep, that's correct.
How often were outages? How often did you experience water outages while Blevins was in charge of your system?
Oh, at least 3-4 times a year. The worst was in the winter, and I tried to remediate some of that by, like I said, I'd go over there and I'd put the heater in there, make sure that the door was sealed. I put spray foam under the door to try to close some of the gaps. So I'd say 3-4 times a year it would go out.
And for what length of time would an average outage be?
For the most part, it wasn't. For the most part, it wasn't more than a day.
How about water quality?
Water pressure, you never knew. There's one instance last fall where all of a sudden the water pressure got up to 110 or 115 PSI, Mr. Blevins stated, when it was spraying like crazy, that we had complications and problems. There were other days when the water was a really slow rate. It kind of was up and down. It depended on how many people that were on the system were using their showers, washing dishes, and things like that at the same time.
Did you notice anything in particular about the water? Was the water underchlorinated, overchlorinated, full of debris? Just fine?
The only thing that, not really full of debris, I know we put a filter in our basement to make sure and clean out any of the debris and things like that, and to kind of purify the water a little bit. Probably you could always tell whenever DNR was gonna come out and inspect, because it would be chlorine. You would definitely smell the bleach. So we just have to run the outside garden hose for a while, let it just drain out, and then that would go away. But other than that, no, we've had really clear water.
I don't have any further questions. Mr. Blevins, do you have any recross examination based upon my questions?
Let me think a minute, please. In reference to the Taylor well, do you know when? No, I have no further questions, Your Honor.
Any redirect?
No,
Okay.
I'm sorry, no.
All right. Mr. Group, thank you for testifying today, and you may step down.
All right, thank you.
It is 12:07. It is 12:07 right now. I'd like to break for lunch for about an hour till 1:07. So why don't we go off the record and everybody be back here at 1:07? When we left off, we had just released witness Jeff Grube. Staff, you may call your next witness.
Thank you. Call Lori Jean.
And Ms. Jean, if you'll come down to the witness stand and raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes.
Please be seated. Staff, go ahead.
Thank you. Good afternoon.
Hello.
Could you please state your name and spell it for the record?
Lori, Lori, last name is Jean, Jean.
And are you currently employed with anyone?
I'm self-employed with 2 different jobs.
Okay. And do you act as a certified operator for any public water systems here in Missouri?
I have approximately 17 right now.
And where are they located?
Mostly in the southwest and southeastern regions. I don't have any more in the central region of Missouri.
Okay. And were any of these, excuse me, are or were any of these owned or run by Travis Blevins?
I did have 3 systems that were owned by Mr. Blevins.
Do you have those
They were,
systems anymore?
No, I do not.
And
I resigned on the 3rd of February, and my last day officially with him was March 3rd.
Okay. And which systems were you?
Rolling Hills, Charity, and Misty Mountain.
And what about Jeff Grube? Are you certified, or were you the certified operator for him?
For less than a month. They didn't end up having to stay with the DNR as a certified system, so I only tested 1 time.
Okay, and that was the Tigger HOA?
Yes.
Are there any other homeowners associations that you know of that?
I have other homeowners associations, but not in Pulaski County.
Okay. And how long have you been working as a certified operator for water systems?
For 21 years.
And does that, do you have any special training or education or licensure?
I know now they make people go to classes and different things, but when I became certified, I was working for a mobile home park that I didn't know needed an operator. And so I worked full-time then at a hospital. So I just went and got the testing materials from the Southwest Regional Office, bought books, home studied, and then went and took the tests.
Okay. And is there any continuing kind of education or continuing training that you do?
Yeah, we have to renew every 3 years. I don't remember exactly how many units you have to have, how many hours, but I have to take, I want to say it's 30 that I have to take for distribution and then 30 for treatment.
And can you explain what kind of training that is?
Well, there's different levels of a certified operator. There's a DS1, a DS2, and a DS3. I am a DS2. Then I also carry a certification for treatment, a Class C.
Okay. And can you just explain just generally what kind of training that is? What kind of education you had?
The continuing education is a lot of math. They have us keep retesting on our ability to do the math, because the math can be quite complicated, especially working with treatment. You have to be able to measure how much are in tanks and different things like that. And then there's constant updates as to policy, DNR policy, and keeping up on what's coming down the pike and what's been handed down from the EPA. So.
And does that include like how to test systems?
How to collect the samples, yes. That hasn't changed much in 20 years. I mean, the collection of the samples is pretty much the same. Some of them have become a little more aggressive. We have the routine bacterial samples that have to be taken each month, but there are other samples that have to be collected. Right now, we're doing a lot of training and learning about the lead service line issues that's all over the country.
And so, so being a certified operator, what does that What does that entail for a public water system like the ones Mr. Blevins had?
The water system owner or operator, they hire us to advise them and help them stay in compliance with the DNR. That's my best description of it, is to keep them in line with the rules and regulations of the DNR. And we work basically as advisors and testers. Some people test their own wells and have a certified operator just on paper, but if I'm on there as their operator, then I test their system.
And were you doing that for Mr. Blevins?
Yes.
And how long were you doing that for him?
From August of 22, I first talked to him in August of 22. I think my first sampling was September of 22 until March of this year.
Do you know if there was a certified operator before you started?
There wasn't, to my knowledge. He had just been activated as a system recently to that.
Oh, okay. And by activated, you mean by DNR?
DNR activated
became-
his systems as, some of his water systems as public water systems.
Okay, you say some, what do you mean by, were there others that were not certified by DNR?
Yes, he had another well. The only one I know by name is Rowden, that they call Rowden. And the only reason I found out about them is because one of those customers called me and wanted to know why I raised their water rates.
Did you raise their water rates?
No, I have nothing to do with water rates.
And as a certified operator, do you get paid to do that?
Yes, we have the right to set our own fee, and I base mine, as to the frequently that I have to go out there to a well and how far it is from, how far my travel time is.
And did you get paid by Mr. Blevins while you were his certified operator?
All but 1 month,
Okay. And what month was that?
the last month.
And in comparison to other, I guess, is there a comparison between the other water systems that you were certified or are a certified operator and Mr. Blevins as to how much you got paid?
Yes, I actually had kind of discounted it, even though I consider my general working area to be the 3 counties near where I live, which would be Christian, Greene, and Webster County, Missouri. Usually if I go outside that area, it's a little higher. I didn't charge him the higher rate that I charge. For instance, I'm also the contract operator for Royal Oak Charcoal in Salem. That's quite a travel, so they pay a higher rate. His rate was, per system, was $75 cheaper per system.
Is there any reason for that?
I live near I-44 at Marshfield. It's a very easy drive, so.
And is there like an average compensation that certified operators receive?
If there is, I don't know. I've just
Okay.
always set my own rates.
Okay. And what are your obligations to the well or the system owner?
Well, to make him aware of, changes, that, bringing the wells up to par and letting him know how his testing is going, when it's due. I always let him know when I was coming out. In hindsight, I don't know that was really a good idea, but I always tried to communicate well and let him know what the DNR expected, when there was paperwork due, and try to handle it the best I could for him.
You just said you don't know if that was the best thing to notify him ahead of time. What do you mean by that?
On 2 occasions, it was the same water system, Charity, that I had let him know I was coming, and I passed him and his son leaving there as I was going into the... So I questioned whether they were out there doing something to the system prior to me getting in there.
Did you find out if they were?
Later, I had 2 complaints from 2 people on Charity that their water was heavily chlorinated. While I was there, it didn't show any chlorine. I carry a chlorine meter and check that myself, and there wasn't any chlorine. So if they had put some in there,
But you didn't put...
it hadn't fully reached the distribution lines whenever I tested, right? I mean, I literally passed them within a mile
Okay.
of the housing development.
And what are your obligations to DNR?
To keep my license up and to make sure that I do everything I can to help them keep these water well owners up to standards.
And when you say standards, do you mean like, what do you mean, like health and safety or?
Health and safety, documentation, record keeping, all about everything. Trying to, if there's a breach in the system or a loss of pressure, I'm to notify the DNR. I have to be pretty on top of it to get all that information relayed. I have to a lot of times rely on the well owner to let me know what's happening, especially when there's a distance, you know, because some customers will call me, but not, most of my communication was with the well owner.
And what about, what about Mr. Blevins? Would he have, what kind of communication did you have with him?
I always got along very well with Mr. Blevins. If I called him and didn't get him right off, he usually would call me back in a relatively short amount of time. Never had any arguments or anything like that. He always stayed in constant contact with me. There was always, just toward the last few months, I noticed that I wasn't being informed of some things that were not proper. But other than that, I mean, we didn't have any specific issues with our communication.
And the last few minutes, what didn't you find out? What do you mean by there were some things that you weren't told?
There was a water system, or after the, what they call the topo well was moved on to Pulaski County, there was apparently a break at one of the residents' houses, and he called me and told me on a Sunday that they were digging this place up, trying to figure out what was happening. And he said it happened the day before, that this break or breach happened the day before. And he said, I'm sorry, I just couldn't, I know I'm supposed to call you, but I just haven't had time while we're digging this up. Come to find out, had actually broke the Thursday before.
Okay, so what, so it wasn't the day before, it was several days
Right.
before?
And that concerned me that, you know, if this digging had been going on here, he had had no contact with me so that I could turn in a low pressure report. I really don't know how long he'd even been in contact with the DNR. I believe a couple of residents contacted the DNR.
And did you ever act on your own did you ever do anything with the well systems that you didn't communicate with Mr. Blevins?
Not really, no.
And excuse me. And do the system owners or operators, can they act on their own without letting you know?
Some things they can, and there's other things they cannot. Low pressure vents, to me, absolutely they shouldn't. They need to contact their certified operator and let us know so we can investigate, and we are obligated to inform the DNR.
Okay. And did that ever happen when you were the CO
No.
for? So were your duties as a certified operator for Mr. Blevins' public water systems, was that any different than the duties you had for any others?
The duties are essentially the same. They might have some different testing requirements and things for different types of systems. There's, you know, what you do for a residential well will not be what you do for a factory's well.
Okay. But your duties with his wells were pretty much the same as you would have for any other well that you were a certified operator for?
Mm-hmm. Yes.
And can you describe the condition of his well systems that you were responsible for?
Some of them are very nice, very well taken care of, have nice well houses, especially the Charity system. Charity, the three wells that were operational. There was one that did not work. The other three were well cared for. Everything was clean, neat, not a lot of bugs. Bugs are natural. I mean, they're going to be in a well house. They like that moisture and the heat and everything. So those were very well maintained. Rolling Hills, the well house there is almost inaccessible. It's basically just a little, what I call a dog house, a short, small building that just barely covers the top of and the door would not stay on it. And it was very dirty, dark, and spider-ridden. Not fun.
Did that concern you?
Yeah, it did. And I mentioned it a few times that we needed to get that fixed, and it didn't go anywhere. So I just kept brushing back the cobwebs and move on. They're not the worst well houses I've ever seen, certainly.
Okay, and what about were there any other well houses that were?
The Misty Mountain ones varied. The Topo well house was actually probably in one of the best conditions of the other Misty Mountain buildings. Those buildings, I mean, they were, like I said, I've seen much worse. His are certainly not the worst well houses I've ever seen. But they're not the best either. Misty Mountains could have, especially the Tigger 1 well, what they call the big well, it was in a pretty rough state for quite some time. Then it got cleaned up late summer last year, early fall, some in there. I think it finally got in there and got all the debris and some stuff that I think they were storing in there got moved out. New gravel, I think, was chat or something was spread. Much better conditions.
And do you know who did that?
I assumed Mr. Blevins did, but I did not specifically ask who did it. I know Mr. Blevins instructed it to be done.
Okay. And what about the other well houses that you said weren't in great shape? How would you describe them?
Well, like I said, the worst of them was that Tigger 1 well. Like Charities were fine. Several of them on Misty Mountain were fine. I thought the Topo well house was fine, but the Topo well had the biggest problems, the well itself. But the well house was properly constructed. It just was small, and when he was having these troubles with this E. coli, and I suggested that the easiest thing for him to do would be go on chlorination, that well house was not going to be acceptable because there was no room to add storage for the water retention. So when you inject chlorine, you have to have some way of retaining that water so that it gets proper contact time with the chlorine.
And that wasn't available in that?
It wouldn't have been in that well house, and being right there in somebody's yard, I didn't know how he would do storage other than to build a bigger well house and put larger tanks inside of it.
Was that ever done?
No.
Now, over the course of the time you were a certified operator, what was the how responsive was Mr. Blevins when something was wrong or when something?
Well, I really don't know, because I always found out what was wrong or happening after it happened. I never received a call telling me something was going to happen, which in this business, you don't really know when things are going to happen. But if he was going to work on something, I wasn't informed of it.
I'm sorry.
Only when there was a problem and then he was working on it was I informed.
Were you supposed to be informed?
Yes.
If he was?
I should have been informed of pretty much everything.
And can you give some examples?
Repairing lines. Anytime you take the well off the system, I should have been called.
And
If
were
the well
you?
was not, no.
I'm sorry.
Not until later. Not as soon as I should have been.
Okay. And so what kinds of actions would you take that he wouldn't that he was supposed to tell you but didn't tell you until afterwards?
Well, like when the one home there on Topo had to be dug up, I should have been informed the day he discovered it, not 4 days later.
And did you report that to anyone, or did you?
I spoke to, I believe it was Dalton Young, and I've got the feeling, I have several systems, so it's kind of hard to keep them all track, but I think he already knew before I did.
And that, he's from DNR?
Yes.
Okay. And did you ever tell Mr. Blevins about your concerns about him not telling you right away?
We spoke about that multiple times, that I needed to be informed when there was ever anything wrong with the wells.
And what was his reaction?
Okay.
Did he do it?
No, no. Not breaks. I mean, if, a couple of times I believe he told me he was not gonna be available, that he had doctor's appointments, or he was taking his wife somewhere to be seen, but not, I don't think I was ever informed on the day that something happened, that there was a event. I don't believe I ever received a call the same day.
Was it always several days later, or how soon?
2 or more.
Okay.
2 or more days.
And Ms. Aslin's going to hand you what's been marked, I believe we're on Exhibit 7.
Thank you.
And do you recognize what these are?
Yes.
I believe there's 3 of them.
Yeah, they're the contract operator agreements that I prepare for each of my water systems.
And there's one for Rolling Hills, one for Charity, and one for Misty Waterworks?
Yes,
Okay. And are they all about the same language?
exactly. They should be almost exactly the same.
And while you were, and what does it set forth about what your responsibilities are, or the certified operator responsibilities are?
Of course, my main thing is that I needed to make sure that all the testing was done appropriately, on time. There's timing issues we have to meet with getting a sample drawn, to getting it to a lab, making sure all of that happens in a timely manner and appropriately. Preparing the documentation that goes along with them, and these other samples that come up throughout the year. We have time limits on all of that. So I have to meet all those time restrictions, and, keep an owner informed of if I saw something that maybe needed some maintenance. The inspections that DNR does, I always take them, break them down on a spreadsheet so that we can stay on top of the things that need to be addressed, because some things are recommendations, some things are not satisfactory, and then other things are straight out violations. So you have to kind of take them in a priority.
Okay. And so did these agreements, did they also set out what Mr. Blevins' responsibilities were in any way?
Yes, that he was, his main thing, other than, of course, to make sure I got paid, was to, inform me of any changes or anything with the system.
And so you operated under the understanding of these agreements, right?
Correct.
While you were his certified operator?
Correct.
And would you say that you met your obligations under the agreements?
I feel like I did, yes.
And do you feel like Mr. Blevins met all of his obligations under that agreement, those agreements?
That's kind of difficult to say, because for the first probably 6 months that I worked for Mr. Blevins, I honestly felt like he was being picked on. I've worked in many nursing homes and hospitals, and I have a kind of an affection for elderly people. So I kind of felt bad for him for a long time, that And I do think that one particular DNR person was very hard on him. As time went on, I started realizing that some of the things that he could have been doing, he just wasn't. But yeah, I kind of went into this at first thinking he was really being picked on really badly.
And you said that changed?
Well, that person left the DNR,
Okay.
or left him to another position. But I'm just so used to the southeast and southwest regions where I felt like they are a little more communicative, helpful at answering questions and things. Once that person left their position at Central Field Office, things got better. I mean, as far as the communication, I didn't feel like, okay, they're just picking on him. That kind of went away. Some of it was because I realized what he was doing, and some of it was that I think we got a nicer person that just wasn't hell-bent on punishing him. I kind of felt like that was how it was in the beginning.
And since then, you mentioned some of the things were things he was doing. What do you mean by that?
Well, it wasn't that he was specifically doing anything, it was that he wasn't doing. And I really do believe in partly that Mr. Blevins is what he considers urgent and what some of the rest of us consider urgent items are in two different playing fields. You know, and maybe it's him coming from a different generation, that being without water, you figure it out. You know, the old timers, they figured out what to do. They didn't have wells. Nowadays, you know, if the water goes off a second, I also manage mobile home parks. If the water's off for 5 seconds, these people are blowing the phone up. You know, so our shift in what's an emergency and what's not is much different, I think, than how he sees it.
And what about how DNR sees it?
DNR sees it, you know, we've got to stay on top of everything all the time, and I think rightfully so. That's my opinion. But I do believe Mr. Blevins has a different skew of that.
Okay. So he didn't necessarily go along with his idea of what's important isn't necessarily what the regulations say are important?
Yeah, I think there's just a different way that they're looking at things totally. He doesn't see people being without water as being urgent. You get out there and, yeah, he wanted to fix it, but it wasn't an, okay, I'll get out there when I can kind of thing. And it's more urgent than that when you're dealing with regulations and the public.
Was that did that seem to be generally how he acted?
Yeah.
Can I ask that Exhibit 7 be entered into evidence?
Mr. Blevins, do you have any objection to admitting Exhibit 7, the system operator contracts, onto the hearing record?
No objection.
Exhibit 7 is admitted onto the hearing record. And I'm sorry, just to go back to that and for the record, on all those agreements, looks like you signed them all. Is that
Yes.
accurate? Okay. And so both you and Mr. Blevins signed them?
Yes.
Okay. Thank you. So you said you are no longer his certified operator, and that was sometime in March of this year?
Well, I resigned the 3rd of February, so I took his February samples, and as of technically 30 days is what's written in the contract that I need to give notice, or he needs to give me notice. And so I didn't take, I took March's samples, but not April's. Or excuse me, I took February's and not March.
Okay. And was there any reason for you deciding not to be his certified operator?
There was several reasons. One of them was because we had an incident. I don't recall the month, but it was couple, maybe 3 months before, where I went up there. That area, certain parts of it are not the nicest neighborhoods. Never really bothered me too much until I had an altercation with his grandson. Then after that, I had reservations about going.
And so did you decide no longer to be a certified operator, or did he
I did.
decide? Okay. Do you know if he has a new certified operator?
I don't know.
Okay. Do you know, is he, excuse me, is it your understanding that as long as his water system, as long as some of the well systems are regulated by DNR, those systems need to have a certified operator?
Yes.
So compared to the other systems that you work with, how would you describe his his ability to meet the standards of the DNR regulations?
Compared to the other systems I have, I have some that I have the same issues with. But the majority, they act pretty quickly. But the majority of what I have are also factories that are owned by large businesses.
Okay. Did you have, when you did the water samples, well, never mind, strike that. I don't think I have any other questions right now.
Mr. Blevins, do you have any cross-examination for this witness?
I do. I would. Ms. Jean, you indicated that informed of things going on. Was there anything specific there that was going on that you could relate to?
I had heard from residents in some of your housing developments that you or your son were putting chlorine down the well prior to my arrival.
I see. I don't recall that, but okay. And also indicated one system was broke. What system was that? Was that up on Topo?
No, the one, when I said there were 3 working wells and one that was broken, that's Charity, and that's the one you called the concrete well.
Oh, yeah.
It was never in operation the entire time I worked for you.
No, that's correct. Yeah. I thought that's the one you said had low pressure. Or the broke one.
There's been low pressure at every system during the time that I worked for you. I mean, at different times.
At different times?
Different times,
Yeah.
different reasons.
I hope we addressed those when we found out. Rolling Hills, you referred to it as the doghouse. What is it constructed of?
It had plywood.
That's the concrete well, though, right? I know it's
No, it
difficult
was-
to get it in and out.
It may have had some concrete to it, but I know that there was a plywood door that just, no
Yeah,
matter what you did to it, it just fell off and fell back on the ground.
yeah. The plywood door, that's correct. But the entire house is concrete, even the roof.
Well, even though it's concrete, doesn't mean it was clean and kept up well.
Right. I can agree with that, too. I just wondered really what you meant there as a doghouse.
Well, a doghouse, I'm meaning the size-wise of a
Okay.
large doghouse.
I know it's hard to get in and out of. You
Extremely.
have to step down. I can't hardly get in myself. but I didn't construct it. And urgency, you're correct in my opinion as to what is urgent. I always considered everything to be urgent, I think. Did you mean that I would pay no attention whatsoever to it?
You seem to understand what was going on. I just don't think you acted as quickly as someone else might have.
Okay. Oh, grandson.
Yes.
Again, I would apologize. The problem you had with that is uncalled for. I have the same problem, so does my wife. And at the present time, he's back in prison. So I can't, I'm sorry that that encounter even happened. He was not even supposed to be on our property. And especially to have a conflict with somebody that pulled up in there. You did indicate that there was still a payment due?
Yes.
That's for which payment?
The last payment. You had always paid me, most of my customers pay me right after I finish going to a property.
Yeah,
You always paid me the following month. I never got the one for the last month.
Okay, I'll make sure you get that in the mail, Miss Jean.
I've sent you several
Have you?
invoices. Yes.
That's very possible.
One of them was in the last letters that the PSC had sent that ended up coming to my house in April, I believe it was. There was 3 letters from the PSC that came to my home, again, addressed to the legal department.
Yeah, I don't know why they addressed you as the legal department.
So I sent those to you in a certified letter, and you did receive them with a bill.
Oh, okay. Very possible. I apologize for that, but I'll make sure it gets paid to you. I would like to make a comment that not a question or anything, but I did appreciate your work when you did work with us.
Thank you.
You were professional in every aspect that I'm aware of, so thank you. I had no further questions.
Any commission questions for this witness? I hear none. Ms. Jean, I have a few questions for you.
Okay.
You had started off by saying there's 3 levels of training, DS1, 2, and 3, and you said you're a DS2. Is that correct?
Yes.
What's the difference between those 3
The level of
classifications?
education.
Okay.
And what you're trained on lets you work for different size systems. A 1 is a very small system like Mr. Blevins. I did not need to have a DS2 to work for him. I got a DS2 because of the system that I originally started with in Nixa, Missouri, required a DS2 in a treatment class C. So I tested for the type of system. So each one goes according to how many residents and what different types of things you would be doing, but mostly the size of the system
Okay, so a DS3 would be a larger system.
would be a very large system.
And just from my understanding, the system you started out on was a mobile home park, is that correct?
Yes.
Now, you said you got the impression that a DNR employee was picking on Mr. Blevins. What DNR employee was that?
Sebastian Cloverside.
And what particular made you feel like he was picking on Mr. Blevins?
He just seemed very abrupt with him and almost rude at times. He even made, we had almost an argument, Sebastian and I, over the fact that he told me one day he was going to get him. And I said, that's not really your job to get him. I said, why aren't you helping him? Because at first I thought they weren't offering any assistance. And later they were. They were offering him more technical assistance and trying to, but at first it sure didn't seem like that. It was very, this is the regulation, this is what you're going to do, or I'm going to get you.
Okay. You said that later that at first it did not appear that they were providing him any assistance, but later they did. Do you know what changed?
Well, it seemed like Dalton and another young man, I don't remember his name, were more involved. Then Jackie got involved, Jackie Johnson, and the other Jackie. There was another Jackie before her. They started giving him more advice and trying to get him to comply with things, and were talking to him, I think, more on his level than talking at him, spouting regulation numbers that didn't mean anything to him.
Well, when would you say this change occurred?
It started gradually, but then tremendously improved after Mr. Cloverside left the Central Field office.
Do you know when that was?
I don't remember the date, I'm sorry.
Do you remember a month?
I want to say it was last summer,
Midsummer of last year?
somewhere around there, yeah.
So midsummer of 2023?
Correct.
The altercation that you had with Mr. Blevins' grandson, was that water related?
I was trying to be paid. Mr. Blevins had told me to go to his antique store to pick up a check from Amanda, a young woman that worked as his kind of secretary or assistant. And I got there and she was not there. I was told she was at her residence across the road and up about a very short distance, just a few hundred yards, when his grandson approached me and demanded to know why I was there, and then grabbed me by the arm.
Bear with me just a moment. Now, I know you were in the room during the last witness, correct?
Correct.
And you heard me say that I don't really have a good understanding of these systems. Can you give me a better understanding of these systems, like kind of what their makeup is?
Do you mean as far as one well to another at the distance, or?
I mean, these 3 wells, 2 are in good shape, 1 is inoperable, serve 9 connections,
On Charity,
prone to lakes, prone to bacteria.
on the Charity system, 2 of the well houses, both of them located on the Charity Lane on the same street, were in excellent water well houses, kept clean, were in pretty good shape and didn't have much issues. The one he calls the concrete well did not work at all, never did work the entire time that I worked for him. Was just a concrete little slab building and right along Highway PP, and never did work. As far as I don't know when it last worked. Somebody apparently ran over it, is what I was told, and caused it to be inoperable.
But that system on the whole ran well, the Charity system?
It's on the Charity system.
I mean, was that well necessary to the system, or is the system run okay without it?
It's running, it seemed to be running fine without it, but I don't live there, so I don't know how good of pressure people are getting. I've heard complaints of pressure problems, but usually it was from a leak or something of that nature. Sometimes these wells, they're designed to only serve a few houses, but they've been well constructed for a residential well, and will pump to so many, but that only lasts so long before it just becomes hard on pumps and equipment to keep that moving.
Okay. Now, you indicated that the Rolling Hills well had the worst well house, correct?
That I want to say Tigger 2 on the Misty Mountain was the worst well house, but the one on Rolling Hills was a very close second.
Okay. And how many wells are in the Rolling Hills system?
Just one.
And what well is that?
It just was the one.
It just goes by Rolling
Yeah,
Hills?
Rolling Hills well.
Okay. And then the Misty Mountain system?
Misty Mountain consisted of multiple wells. There was Patricia, Topo, 2 wells on Tigger Lane, Tigger 1 and Tigger 2, and then Taylor. I never had to sample from Taylor because it did not work while I worked for Mr. Blevins.
Now, were you there during any of the incidences with the topo well?
Yes, I came into it, it was already on a boil order. And it was a mess. I mean, we'd get a good test, come back, you had to come back so many days later after you took a number of tests, like get those results, you'd have to then go back and take another series to try to get it off boil order, and it would be bad again. So chlorine shocking it was not cleaning out whatever was causing the E. coli.
And that well ultimately failed, correctly?
Yes.
Correct?
Yes,
And were you the system operator when that well failed?
I was.
And do you know what caused it to fail?
It broke right at or just below the pitless adapter and caused parts of it to plummet into the well.
Now, how many connections were on the rolling hills?
I believe I had in my records 15. So
And Misty
just-
Mountain?
Yep. Misty Mountain, I've never known an exact number because one well would be not considered part of it, and then they put another one back on it, that they thought Mr. Blevins had sold them. So it varied all the time I never had a good number.
Okay. Now, you're currently the system operator for the Tigger 1 well, is that correct?
Not anymore.
I'm sorry.
As of 6th of this month, I'm not.
You were the system
Just for
operator?
1 month.
Okay,
I only
and
did
that
1
has-
month's of testing.
And that has 9 connections, correct?
Yes. Actually, it had more at that time because Taylor was still feeding off of that well. So I want to say it had 15.
And I know that the Taylor well was not operational while you were there. Do you know how many houses were connected to the Taylor well?
4 or 5.
And the Tricia well was also part of the Misty Mountain system?
Yes.
And how many connections were on the Tricia well?
3, I believe.
Do you know why these systems were classified as, well, no, I'm sorry, that's a better question for DNR. Never mind. I have no further questions for this witness. Mr. Blevins, do you have any recross based upon my questions?
No, no.
Any redirect from staff?
You said that, you'd said that, to the wells, not I guess the Rolling Hills and the Misty Waters or Misty Mountain, those houses were not well kept. What did you mean by that?
Well, the one on Tigger 2, or excuse me, Tigger 1, with the big well, there was a lot of debris inside that well house for a very long time. Wires, a couple of pieces of metal, and just it was a dirt floor well house, which is not uncommon, but it was not kept very well. It had a lot of debris, just like junk thrown inside the corner of the well house, but that did all get cleaned up eventually.
Could you know if that got cleaned up after the Tigger 1 well became part of the HOA?
No,
That
this
was-
was before,
Okay.
well before.
And what about the Rolling Hills? You said, is
That
that
well house
also,
was still the same when I left his employ.
and what do you mean by that?
It had never, the door still wouldn't stay on. It was just a concrete and plywood hut kind of
Okay.
over it.
I don't have any other questions, thank you.
Thank you, Ms. Jean. You may step down.
Okay, Jackie. Thank you.
Staff, you may call your next witness.
call Jackie Johnson.
Ms. Johnson, would you raise your right hand and be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes.
Please be seated. Staff, you may go ahead.
Thank you. That's three. Okay, I got it. All right, thank you. Good afternoon. And could you please state your name and spell it for the record?
Jackie Johnson, JACKIE JOHNSON.
And by whom are you employed and in what position?
I am an environmental program specialist with the Missouri Department of Natural Resources.
And how long have you been in that position?
I've been in my section for 5 years. I was an environmental program, oh my gosh, I've blanked, analyst, and then I became an environmental program specialist, but I've been in the same group for the 5 years.
Okay. And have you worked with DNR? How long have you been with DNR?
5 years.
Just 5 years. Okay. All right. I wasn't sure if I understood that. And what are your duties and responsibilities in the position you're in?
I am a case manager, so I provide compliance assistance to systems that have been referred to enforcement, and then I also provide compliance assistance in general to systems with various types of violations.
And are you familiar with Mr. Blevins?
Yes.
And how did you become familiar with him or with his case?
I took over as the case manager for the various Blevins cases after a previous case manager, Jackie Hooker, left for a different position.
Okay. Had you been in a case man, or had you been in that position that was within the last 5 years then?
Yes.
Okay. And then what's been your involvement with his case in particular?
Since I took over, I was the one who drafted the administrative order for Misty Mountain, and then the administrative order on consent for Rolling Hills, and then the revised proposed versions of the administrative order on consent for Charity.
And how often do you talk to Mr. Blevins about his cases?
It varies, but a lot. I would say we probably average about once every other week we speak.
Is that about the same as you do with other systems that you're dealing with?
No, I do talk to Mr. Blevins far more often than for my other cases.
Okay, and do you know why that is, or do you have any reason? Do you have any ideas why?
Well, part of it is that there are 3 cases with the same responsible party, so that's going to cause more communication. But also, we talk a lot about the different things that need to be done for the different cases. While I do communicate through writing and through emails, I think based off of my conversations, Mr. Blevins prefers to talk versus get an email.
And does he call you? You call him?
Both.
Okay. And when you reach out to him, how responsive is he?
He is really responsive. He takes my calls when he's available. If he isn't able to, he will call me back in a pretty short period of time. I don't get as much response from written correspondence, whether it's letters or emails.
And when you ask for him to give you something or get back to you with an answer, how responsive is he then?
I have had some trouble getting things returned by deadlines. I do usually get a response eventually, but it's not usually in a timely manner as far as if there's a deadline for something to be turned in, those deadlines are usually not met.
Okay. And you said you have 3 cases open with regard to Mr. Blevins?
Yes.
And how long have they been open, or have you been working on them with, do you know?
Yeah, so it's kind of 2 parts because I took over. So the 3 systems were sort of officially referred to enforcement in November of 2022. And then I took over as the case manager from the previous case manager around February of 2023. And then we've continued working through that process since then.
And we're talking about the same three that other people have testified to, the Misty Mountain, Charity, and Rolling Hills water systems?
Yes.
Okay, just wanted to make sure we're all talking about the same thing. So when a case gets to you, how does a case get to your section or to get to you?
Typically, it will start with the regional office. So they will be working with the system that may have violations or, there's some ongoing issues. If their compliance assistance isn't successful in returning a system to compliance, then it would get referred to us. It can be based off of a formal referral from the regional office, or sometimes we become aware of situations. So in this case, because this was a new system, specifically Misty Mountain, we didn't really have a long history of compliance issues. As soon as they started collecting samples, we had the E. coli, and that wasn't getting better, and their actions weren't being taken to return them to compliance. So in that case, it got referred to enforcement pretty quickly compared to a normal system. And then Charity and Rolling Hills, we already had identified had non-compliant wells, and the solution to that is enforcement. And so that's why these all kind of came directly to enforcement without necessarily having to go through some of that earlier compliance assistance.
And so what kind of resolutions are possible then in these cases?
Once it gets referred to enforcement, we have a couple of options for formal enforcement actions. The first is what we call an administrative order on consent, or AOC. That is a negotiated agreement between the system and Department of Natural Resources for certain actions that have to be taken, and so there will be deadlines. An AOC may contain an administrative penalty if there were violations, but it gets sent to the system, they would sign it, it comes back to DNR, we would sign it, and it becomes effective. If a system won't participate in that negotiation or we can't reach an agreement, we have the option to have an administrative order or an AO, and that is a unilateral order. It becomes effective just with the department's signature. It's not a negotiated agreement. We also have those as an option if we don't think that normal AOC process is going to be successful, or if there are things like an urgent health risk. If they have signed an AOC, or we have the administrative order, the AO, and it's not being complied with, we have the option to also escalate enforcement to the Attorney General's office. We can refer a case to them.
And, sorry. And you said sometimes an AO is entered into or not entered into. I guess you just issue an AO, administrative order, if there's an urgent health need. Were any of Mr. Blevins' systems, was the AO that was issued to Mr. Blevins because of that?
We did go with the administrative order, that unilateral order for Misty Mountain. And part of the reasoning behind that, it was twofold. There had been a lack of action toward returning to compliance and determining what was the cause of that ongoing E. coli and the ongoing boil order, but also because it was E. coli and it had been going on for months, it needed to be a faster process than the typical AOC would take.
Okay. And so are there any other disciplinary actions available to take against the violators by DNR?
We could issue something called an emergency abatement order. Those, it's built into statute. If there is a imminent health risk, we can issue, we call it an EAO, emergency abatement order. Those are pretty uncommon.
Okay. And then I'll get to that in a minute. Before we get into that too far, can you explain what it means to be a public water system under DNR regulations?
Sure. That definition comes from the federal level from EPA. So a public water system serves at least 15 connections or at least 25 people for an average of at least 60 days out of the year.
Okay. And so how many of Mr. Blevins' systems are considered public water systems under the Missouri Department of or under DNR regulations?
We have 3 regulated systems. We have Misty Mountain, Charity, and Rolling Hills.
So are there some that, are those different than the systems that are not designated as public water systems?
I am aware of other wells that are purportedly owned by Mr. Blevins, such as on Rejoice and on Rowden. Those don't meet that threshold to be a public water supply, either with the connections and or the number of people served.
Okay, so he could be operating some well systems that are not regulated by DNR, and then in addition to the 3 that are regulated by DNR. Is that right? Are you
Yes.
understanding? Okay. And do they get different treatment from DNR? Or are they just not regulated at all?
If they don't meet that threshold, then they're not regulated by DNR.
Okay, do you know if they're regulated by any other agency?
I don't.
And so with the public water systems that Mr. Blevins operates, are there multiple wells that make up the one well system or water system, or how does that work?
Rolling Hills only has 1 well, and that well on its own has enough connections and population served. For Charity, there are 4 wells, 3 that have been functional. The one that's referred to as the concrete well is kind of in the process of coming back online. Those have interconnected distribution systems, but they also have common ownership. So there was a case that kind of established the precedent. It was McGinnis Estates, that if there is that common ownership, even though each individual well may not have enough connections or population served, that together with that common ownership they do. And that's why we regulate, like Charity, for example, as a public water supply, even if the first well on PP doesn't have 15 connections or the 25 people. And it's the same situation at Misty Mountain. While the number of wells involved in Misty Mountain does kind of vary, like Patricia is no longer part of it. The big Tigger well isn't, but Taylor is back in. It still has, as it's waffled back and forth with the different wells, stayed at that threshold of the 15 connections and or 25 people served at least 60 days out of the year. And they do have that common ownership, which is why they get to count together.
Okay. So now with regard to Mr. Blevins' well systems, there have been references to Misty Mountain, and then there's Misty Waterworks. Do you know what the difference is? Can you explain that?
As Mr. Grube was testifying, it's been hard to tell who the continuing operating authority is. So that's why in our order we refer to specifically Leon Travis Blevins and Patricia Blevins, because in the documentation that's available, say through Pulaski County, through their recorder, a lot of the records for the different properties and wells have both of their names on them. And so we put a specific corrective action in the 3 orders that we have, that whatever that continuing operating authority is needs to be registered with the Secretary of State.
Okay, and you're talking about if that's a business or if that's registered as a business?
Yeah, if you go to the Missouri Secretary of State site and try and find Misty Waterworks, it's not a registered business entity, neither is Outlaws Corral, or we weren't able to find any LLCs or corporations or anything, which makes it hard to know who the responsible party is, especially when documentation exists with a name that doesn't necessarily truly exist, as far as being registered with the Secretary of State. So we have written our orders referring to that Misty Waterworks because it was at least used for some of the time as the operating authority. But that will be something that needs to get sort of cleaned up and cleared up through our administrative orders is whatever that actual operating authority is needs to be registered with the Secretary of State.
And whose responsibility is that to do that, to fix that?
That would be the Blevins.
And have they done that, or has he done that yet?
Kind of. So Mr. Blevins did register an HOA for each of the systems. So there is a Misty Mountain Water Supply HOA and one for Charity and one for Rolling Hills. The issue that I ran into for our cases is that while those HOAs were registered, I was never given a copy of the bylaws that would show that there actually is an HOA or any sort of information about membership because, like as Mr. Grube was talking about, residents that were joining the HOA were supposed to pay a fee and then continue paying a water fee. And I don't know that anyone ever actually joined. So while these 3 entities were registered with the Missouri Secretary of State, I don't know that they actually have any involvement in the operation of these 3 water supplies.
Okay. So, so is there a centralized distribution system for the wells that provide water system to all the residents? Or how, you might have already answered this, but.
Well, yeah, it's complicated. So like at Rolling Hills, it has a single well and a single distribution system. That one's simple. At Charity, there are 3 functioning wells, one that's on its way, and those distribution systems are interconnected. And then at Misty Mountain, they are not. So for example, the homes on Taylor that are served by the Taylor well, now that Tigger 1, the big Tigger well, is disconnected, those homes are only served by their own distribution system. Same for the homes on Topo, they have their own distribution system, and it's the same way for each of those. So the short answer is it's different at each one.
Okay. So as the operator of a public water system, what's the operator's, what's required of the operator? Anything under DNR?
Under 10 CSR 60-14, so that's chapter 14 in our Code of State Regulations with drinking water regulations, it defines what is a chief operator and what their responsibilities are. So ultimately, they're responsible for the quality and the quantity of water provided at a system that's required to have a certified operator.
Okay, and is Mr. Blevins complying with those requirements with regard to all 3 of the public water systems?
No.
And what do you mean? Could you explain that?
So because Charity and Misty Mountain and Rolling Hills Public Water Supplies are all community public water systems, they are required to have a properly certified chief operator. They're each classified as level DS1 or distribution level 1. So they have to have an operator with at least that certification. And at this time, they do not.
Are there any other requirements of the public water systems that Mr. Blevins' systems are not complying with?
Yes.
And what are they?
All of those systems, Charity, Rolling Hills, and Misty Mountain, are required to collect one routine, well, I shouldn't say one. They're required to collect bacteriological samples per month. The number of samples varies by system. Rolling Hills collects 1. Misty Mountain collects more because of those separate distribution systems. But either way, they're all required to collect those routine bacteriological samples each month, and that has not happened for all 3 systems for the months of March, April, or May. And we're getting pretty deep into June, and I haven't seen samples yet. And then there was an additional violation at Misty Mountain. Not enough samples were collected, I think, in February.
Okay. And is that usually the certified operator that does that, or the owner, or the actual well operator?
It depends on the system. You do not have to be a properly certified operator to collect those routine samples, but some systems prefer their operator to do it since they're already paying for an operator. They have them also collect the samples.
Right, so could Mr. Blevins collect those samples even though he doesn't have a certified operator right now?
Yes.
And you're saying he hasn't?
Yes.
Is that a concern for DNR?
Yes.
Can you explain why that's a concern?
At this time, we don't know about the safety of the water. Without those routine bacteriological samples, we don't know if the water is bacteriologically safe.
Okay, and, why is that concerning?
People are drinking that water, and so it's important that they know that the water is safe.
And there's been some talk about his wells being non-compliant wells. Can you explain what that means?
As community systems, they're required to have wells that meet certain standards. The wells for all of the systems, Misty Mountain, Charity, and Rolling Hills, were built to either domestic or multifamily standards, not to public water supply standards. And so when we became aware of the systems and we activated them, we did what we call a well determination and looked at what we know about the construction of the wells, standards they were built to. And so all of the wells at those three systems are non-compliant. They were not built to the proper standards for a public water system.
So are they still, even though they're considered non-compliant, could they still be safe, reusable wells? I mean, I suppose they are.
Yes, so that is why we have written some of the orders. So the order for Rolling Hills that Mr. Blevins referred to earlier, that he and his wife signed, that is what we call a non-compliant well agreement. It's a type of administrative order on consent. It acknowledges that the well at Rolling Hills wasn't built to standards, but under certain conditions can continue to be used. And part of that order is a path toward getting a permit to dispense water, which is required of public water supplies. And that permit will also document that the well was non-compliant, and it'll have some stipulations such as not being allowed to add additional connections in the future. The Charity order, which is still in negotiation, is also containing a non-compliant well agreement. And then for Misty Mountain, it's a little more complicated because it has the Topa well, which has collapsed, but it also has the other wells, which are non-compliant.
And is he required to fix those wells or do something to those wells to bring them into compliance, or?
He is not, because what makes them non-compliant comes down to the actual construction. And so a lot of the things like casing depth, casing material, how the grout was applied, that can't be changed once the well is made. So that's why we have these agreements, though, to acknowledge it wasn't built to the proper standards at the time, but there's a path forward to still being able to use those wells.
And what do you mean by path forward?
We have to have this effective non-compliant well agreement, so the effective administrative order on consent. And then it has it's sort of an if-then set of corrective actions built in. So you have to continue collecting your regular samples. If there are issues with those, then additional corrective actions can be triggered, such as if you have E. coli, you may have to add chlorination. And then as long as the sampling is safe and those extra steps are followed if needed, then you can continue to use the well.
So when you issue an AO, an administrative order, an administrative order on consent, when did they become final at some point? Or explain that.
Yeah, so an administrative order is a unilateral order. It's effective upon the date of the department's signature. They can be appealed to the Administrative Hearing Commission for 30 days, and that's built into state statute. If it is appealed and that appeal is denied, say it wasn't filed in a timely manner, then the order is effective. If the appeal is heard by the Administrative Hearing Commission, they make a recommendation. That goes to the Safe Drinking Water Commission, and they can either accept that recommendation or modify it. But they would determine at the end of whatever their decision is, whether that order is going to be upheld or if there needs to be changes to it.
Okay, and then, so does it become final then?
Yes.
Okay. And the administrative order on consent, does that become final? When does that become final?
So that would be effective once it has the party's signature and the department's signature. We have a paragraph at the end of it that's a waiver of right of appeal. Since it's a negotiated agreement, you wouldn't necessarily need to appeal something you've already agreed to, and so we have that in there. So by signing it, you're waiving your right to appeal that order to the Administrative Hearing Commission.
Okay. So as soon as everybody signs it, that's a final order, basically.
Yes.
Okay. And the administrative order, you said that can be appealed to the AHC, Administrative Hearing Commission. And then is that appealable? Do you know?
The appeal of the appeal?
Yes.
I don't know on that.
Okay, that's fine. Now, what happens if the corrective actions, you said there are corrective actions included in those two types of orders?
Yes.
Okay. And what happens if the corrective actions that are ordered or consented to are not met?
If a system has an effective order and they're not complying with it, we will try and use compliance assistance. We'll reach out, we'll remind them of deadlines, we'll try and see if maybe deadlines need to be changed. But if a system is truly just not going to comply with their order, we can refer that case to the Attorney General's office.
And what would the Attorney General's office, would they file it somewhere else?
So they could file in the circuit court to enforce the order.
Okay. And do the corrective actions, would these include fees or penalties that are ordered?
It could. For example, the Misty Mountain order does contain administrative penalties because Misty Mountain had violations that were issued by the department prior to us writing that order. So it does contain an administrative penalty. Not every order, though, does contain penalties.
Okay. And so if the person doesn't pay the penalties or the fees, does that go through the same steps that you might refer that to the AGO?
Yes.
Okay. Okay, so we've been talking about this is the one. We've been talking about the administrative orders. Is 8, right? Yeah, okay. Ms. Aslin's going to hand you what's been marked Exhibit 8, right? 8. So before I get to that document, I have a couple questions. Has DNR filed an administrative action against all 3 systems?
We have an effective order with Misty Mountain and with Rolling Hills. I have been in an extended negotiation process with the order for charity, and so that order is still not effective.
Okay. Okay. All right, so now looking at Exhibit 8, do you recognize what's in those documents?
Yes.
And what is that? Could you explain that?
These are copies of the effective orders for Rolling Hills and for Misty Mountain.
Okay, and does it say on here when they were issued?
It does. If you go to page 20 of the first order, which is the order for Misty Mountain, it has the signature from our department and the date. So that order was issued on December 28th of 2023.
Okay, and then there's the second order for Rolling Hills. Now,
Yes.
that's an administrative order on consent. That one was negotiated?
Yes, for Rolling Hills.
Okay, and that was done when?
Page 15 of 15 of that document shows that the department's signature was May 13th of 2024.
Okay. Now, there's also a letter between the two orders right after the page 20 of 20. Can you explain what that is? Is
So-
that part of the Misty Mountain order, or what? I guess where does that fall in?
We already had an effective administrative order for Misty Mountain, but after that order became effective, Mr. Blevins let us know, well, I guess everybody did, that the Tigger HOA had been formed. And so because our order said that Mr. Blevins owned and was responsible for the Big Tigger well, but that had changed, and it became clear that the responsibility was actually on someone else, we needed to address that. And so rather than issuing a new administrative order, we wrote this letter that says we won't enforce any of the requirements that relate specifically to the Big Tigger well. So the order stands, the effective order for Misty Mountain, and this letter acknowledges that there's been a change with Tigger, and we're not going to enforce anything related to it.
Okay. All right, so it's just kind of an explanatory letter. Okay. So with regard to the first one, to the Misty Mountain administrative order, what were the main problems and violations noted in that one? And you don't have to, read through it, but just generally summarize.
So there is a section that's the statement of violations. Most of the violations relate to the ongoing E. coli issues that were happening at the Topo well, which is part of Misty Mountain. And then not just that it had E. coli, but the failure to correct that and to complete certain required actions. It also acknowledges that there are non-compliant wells being used at the system, and that it does not have a permit to dispense drinking water.
And how long had these problems been going on? Do you know?
The E. coli was an issue as soon as the first samples were collected. So the system was identified in the summer of 2022. We had received some complaints at the department prior to that. It took several months to visit the site and kind of tease apart the ownership because it was confusing, and to figure out which wells were interconnected or which wells had common ownership, which made sense. So once the systems got activated and samples were collected, immediately there was an issue with E. coli at the Topo well on Misty Mountain, and then that continued until the well failed.
And what about the other wells? What problems did you have with those?
We did not have as many issues other than them being non-compliant for the other wells. It was just that which wells were part of Misty Mountain kept changing. So, for example, the Taylor well was owned by someone else. Then it was owned by Mr. Blevins. And then the Tricia well was the one I think that Lori Jean was referring to that kept kind of being in and out of the system because it was unclear if it was actually sold or not. So it was a challenge figuring out which wells were part of Misty Mountain to include in the order.
Okay, and how responsive has Mr. Blevins been to resolving the problems, the issues noted?
He has not paid the administrative penalty, which should have been paid, I believe it was within 30 days of the effective date of the order. He did talk to me about going on a payment plan, but didn't actually provide any proposed payment options. So he instead just has not paid it. He has been continuing to collect the samples up until the past couple of months, which was one of the requirements. He has not plugged the Topo well, and the deadline for that is tomorrow, June 25th. There's a deadline in there of tomorrow, June 25th, also to submit the technical, managerial, and financial capability documentation. So those two deadlines haven't been missed yet, but they're tomorrow. And then, he was required to register the continuing operating authority with the Secretary of State. He did complete, though, he needed to pay the outstanding primacy fee, and that did get paid. However, he has since not paid the laboratory fee, which is now overdue.
Okay, and how long has he not paid the lab fees?
Those fees are due at the end of February. So he would have gotten an invoice in approximately January. They send out a follow-up letter of warning around the end of March or beginning of April, and then violations go out. So there have been several notices, and I've sent him the invoices. But I think right now the current fee right now with the interest is $309.
And does that include last year's fees? Does he still owe those?
No, he did pay the primacy fee, which was from last year, but the laboratory fee for this year has not been paid.
Was there a lab fee for last year?
Because of when he was activated, I'm not sure. I would have to look and see.
Okay. Okay. And so what effect does that have on the safety of the water? The fact that he hasn't done samples, or the fact that samples have come back with E. coli? Excuse me.
So for the ones that were testing positive, there is a chart in this order that goes through all of the different samples that were either total coliform positive or E. coli positive. That is a huge issue because that water is not bacteriologically safe. As far as not paying the fee, if the samples are sent in, we're still testing those. The lab fee isn't being paid. The bigger concern is that, like for that first corrective action, it says we need to continue collecting the required samples, and that hasn't been happening.
So not knowing not having the samples, not knowing what the water is like, what kind of concerns does that bring to DNR?
Well, the concern is that we don't know if the water is safe at this time, especially at this system where we know that there was an ongoing issue with E. coli. While it was on Topo, and Topo Drive residents now get their water from the public water supply district, it's still a concern overall of operation of the system is the water safe? And that's why we collect those samples, or why they submit those samples, is so that we know that the water is safe.
Okay, and you say he hasn't collected those since, or you haven't gotten any since March? Or you didn't get any for March forward?
Correct.
Okay. So what if he still doesn't provide them for the next month and the next month? Is there any action that DNR takes, or?
We will continue to issue monthly violations if there are samples that are not submitted. If these deadlines are not met, those deadlines of tomorrow are really the last deadlines within the order, because submitting this application for the permit to dispense is supposed to be 60 days after all those other actions are finished. If Mr. Blevins is not going to meet his deadlines and not comply with the order, then our next step would be referral to the Attorney General's office. And at that time, while the violations we're talking about for not collecting samples aren't in this order, it could be included in any actions that the Attorney General's office would take.
Okay, is there any notice given to the public about the testing and whether they've been tested and how they've been tested, or what the results are?
So for the routine monthly samples, the bacteriological samples, those are not specifically provided to the customers. We do have a website that customers can go to, which when I went to that public meeting with the Public Service Commission, I went over that with a lot of the people that were there, how to look up their results, and that's available 24 hours a day, 7 days a week through Missouri Drinking Water Watch. So customers can see their routine results, they can see repeat samples, things like that. As far as notifying customers if you don't collect a sample, there is a public notice requirement for each of those violations.
And can you explain that?
So for public notice, a water provider would have to, we send a form for it, but they have to provide that to their customers that explains what happened. They have space on there to write sort of why it happened, and then they put their contact information, and there are specific ways it has to be posted, whether it's a community system or a non-community system. And then the water provider would send back the form that they posted for their customers and a certification for how they notified their customers.
And do you know if Mr. Blevins did that?
He has not done that yet for these current violations, but they're also not overdue. So for the specific type of violation for not collecting your monthly sample, there's a year to complete that public notice.
Okay. So what if he doesn't provide samples for 8 months? Is there something the DNR does, or is there some kind of notice that DNR sends out?
If a system misses 4 or more samples within a rolling 12-month period, then we send them a letter and notify them that they're what we call a chronic monitoring violator. We also post that information on our DNR website of chronic monitoring violators so that the public can be aware that there's a system that is not collecting their samples.
So, March, April, May. So if Mr. Blevins does not provide a sample, I guess would it be for July or August? Would he be then considered a chronic monitoring violator?
I think it would be June, because we haven't gotten samples for March, April, May. If we don't get any for June, then that would be 4 violations within a rolling 12-month period. Those 3, though, are going to hang on for a while. So even if he does collect a sample in June, if he missed one, say, in October, then that would still be 4 violations in a 12-month period. So it's going to be very important, if he does not want to be on that list, that he collects all of his samples forever, which he should anyways. But if the goal is to avoid being a chronic monitoring violator, he has to for at least the next 12 months.
Okay. And about how, are there, what would you say are the number of people that are, or number of operators that are on this, or designated as this chronic monitoring violator? Are there a lot of them? Just a few? I mean, how would you describe that?
It is not a very long list. I looked the other day, I guess it was last week, and I don't think there were even 20 systems on that list.
In the whole state of Missouri?
Yes.
And so usually, for the most part, everybody gets the samples to DNR.
If they miss some, they don't miss that many.
Okay. So on the administrative order for Misty Mountain, were there fines assessed on that one?
Yes.
And is that separate than like lab fees or whatever that was overdue?
Yes, and I want to clarify, I think the word fine gets used the same as penalty. I want to make sure that's what you meant.
Yes, I meant penalties, I'm sorry.
Yes, it does contain an administrative penalty.
And how come there, do you know what the reason was that DNR included an administrative penalty in this first AO?
There were violations that were issued, and so it's, again, built into the drinking water regulations. We can calculate penalties for violations that were issued. So for Misty Mountain, there were several types of violations related to the E. coli and the failure to correct certain things. And so the calculated penalty for that was $6,000.
Has he paid that?
No.
And then you said there were corrective actions included in that AO as well, right?
Yes.
Okay. And has he complied with those corrective actions? Or any of them?
Corrective action 2 was to submit a schedule of compliance that includes the deadline to plug well number 1, which is the topo well. And that deadline is tomorrow. But so far that has not been completed. He did pay the primacy fee, so he did complete that corrective action. He has registered an entity with the Missouri Secretary of State, but again, I don't think that is the entity that's actually operating the water system, so I don't think that completes our corrective action. And then the only other one that has not passed its deadline is that demonstration of technical, managerial, and financial capacity that's due tomorrow. So for now, the only one that's actually really completed is paying the primacy fee, and the others have missed their deadlines except for the 2 that are due tomorrow.
Okay, and how long did he have to take these corrective actions?
It depended on each corrective action. They kind of have their own deadlines. Okay. So for example, for corrective action 1, it's ongoing. That is just to continue collecting the required samples. So that one doesn't really end, but it also isn't being met because he's not collecting the required samples. The schedule of compliance that was supposed to include, plugging the well and everything, that was due within 30 days. He had 180 days to plug the well, which is tomorrow. He needs to complete public notice. That one will kind of keep going because he keeps getting violations that require public notice. He did pay the fees. It was not within 30 days, but he did pay it. He registered the business. Again, I don't know that that actually fixed it. And then he has until tomorrow to submit the technical, managerial, and financial capacity documentation. And then the last corrective action says within 60 days of completion of all of the others, apply for a permit to dispense. But he hasn't completed those, so he can't apply for the permit to dispense.
Okay. And do you have any reason to believe that that those 2 corrective actions that are due tomorrow will get done?
I don't think they will.
And why do you say that?
For plugging the well, it's not as simple as just, dumping some concrete down it. It has to be properly plugged, based off of the requirements. Also in the Code of State Regulations, it's in Chapter 23. That has to be done properly, and it has to be registered with the state. I don't see that happening between now and tomorrow, but it'd be great if it did. And then for demonstrating the technical, managerial, and financial capacity, Mr. Blevins himself said earlier that it was impossible for him to provide certain documentation that you guys had requested. Our checklist requires kind of a lot of documentation, and it's the same information for all 3 systems. There will be a little bit of difference for each one, but overall, as having one responsible party, it would be all the same. And so I just, based off of what he said himself in our conversations, I don't see that will be provided tomorrow.
Has any of the documentation been provided?
No.
And so how easy would you describe this process to get to the resolution, or to get to the AO, where you were at the AO? You know what, forget that. That question didn't quite make sense. Okay, and so turning then to the administrative order on consent for the Rolling Hills, that's the second one in the packet there?
Yes.
Kind of what, that was also entered against Mr. Blevins and his wife?
Yes.
Okay. That was the same for the Misty Waters, Misty Mountain?
Yes.
Sorry. And so that was administrative order on consent, so that one was negotiated with the Blevinses?
Yes.
And how did that come about?
I sent a proposed version of this administrative order on consent at the beginning of January in 2024. Let me check my year. Yes, 2024. It required a 30-day response or signature. I did not receive that. And so I sent a letter that was a failure to respond letter, notifying Mr. Blevins that we have to have a response to this. And so that has a shorter deadline. I think it was 15 days. I did receive a response after that deadline from his attorney that was asking for some changes. One of those specifically for Rolling Hills was to take out the waiver of right to appeal, and I guess because it only had the one well, I think that was the only thing that they were kind of asking for this one. And so once we talked back and forth about what we would or would not change, then Mr. Blevins and his wife still had not signed, so I was really kind of bugging him quite a bit to get him to sign that. And then they did sign it and return it to the department, and then we got our signature and sent it back.
And that was in April
Yes.
of this year. So about 4 months to get the administrative order on consent signed?
Yes.
Does it usually take 4 months?
It depends. It really varies by system. Because this order for Rolling Hills was the most straightforward, it only addresses a single well. Its corrective actions are pretty much related to the non-compliant well. There just wasn't as much to negotiate within this one. And I think it got a little bit muddled with the appeal of the administrative order for Misty Mountain as far as what the attorney was asking for with extensions and things like that. It got a little confusing, but we got that. We cleared up that misunderstanding that those were separate deadlines, and then it kind of moved forward as far as what it took to get this order signed.
And so what, just generally, what are the problems that you had with Rolling Hills?
Really, Rolling Hills is just that it has non-compliant wells and does not have a permit to dispense. So in the statement of violations, those are just the two, is that it's non-compliant and does not have the permit to dispense.
And how long does he have to to do those corrective actions?
Well, the first corrective action is really keep collecting samples. And so right now that's not happening. The second corrective action was to register the business entity, which again, there was an HOA registered, but I don't think that HOA is actually operating the system. And then there were 180 days to submit the technical, managerial, and financial capability documentation, which will be really similar to Misty Mountains. So that needs to be turned in. And then once that's turned in, then apply for the permit to dispense. So this order could be complete as soon as we get the technical, managerial, and financial checklist and documentation and that permit to dispense application. So then we can issue the permit and then it can be closed.
Okay. And you said on Rolling Hills, were there any fees or penalties assessed?
There are no administrative penalties in this order.
Okay. What about any fees?
No, at the time that this was written, there were no overdue fees for this system. Now, since then, Mr. Blevins also hasn't paid the lab fees for Rolling Hills. So that is also $309 as of today.
Okay. And then what about charity? Has he paid the lab fees on charity?
No, and it's the same amount, the $309.
Okay. So he owes $309 for each of the 3 systems.
Yes.
Okay. And so what happens if Mr. Blevins does not meet these corrective actions, does not take these corrective actions on this one?
We would follow the same procedure. We would be able to refer it to the Attorney General's office.
Okay. And what would you say is the probability that Mr. Blevins and I guess Mrs. Blevins would meet the corrective actions on this Rolling Hills AOC?
This one's a lot easier. We really just need him to register the actual continuing operating authority and submit that. We always call it TMF. It's the shorter name for technical, managerial, and financial documentation. So if he would do those 2 things and collect his required monthly samples, then he can apply for his permit and we can close it. If he does meet his requirement for Misty Mountain by putting that TMF documentation together, he can really use it for this system as well because it's still the same operating authorities, technical, managerial, and financial capacity. So I think it kind of depends on how Misty Mountain goes. If he's able to complete that, it should be very easy to complete this.
Okay. I move that Exhibit 8 be entered into evidence.
Mr. Blevins, do you have any objection to admitting Exhibit 8, the Department of Natural Resources administrative orders for Misty Mountain and Rolling Hills onto the hearing record?
No objection.
Exhibit 8 is admitted onto the hearing record. And you may continue, Ms. Kerr.
I'm sorry?
You may continue.
Okay, sorry. Okay, now Mr. Grube testified that he, and I think you even said something earlier about going to the public meeting that the PSC had back in, was it last June? Do you remember attending that?
Yes.
Okay. And, sorry. Could you tell me what your impression was of that meeting?
It was very well attended. It was a pretty big auditorium. Every seat was taken. People were standing. I think it was contentious. There were a lot of people who were very unhappy and shared a lot of their concerns. There's a lot of overlap. Even though PSC regulates utilities, we regulate the drinking water systems, there is kind of some overlap in our involvement in the system. And so I think it was really helpful to have DNR and PSC there to answer questions. I was able to answer a lot of questions about what's required of a public water supply and sampling, how they can see their sample results. And I think that was helpful for people because they wouldn't just know that on their own. But there were a lot of things that we couldn't answer. At the time, we didn't have orders for the systems. We didn't have a good answer for what was going to happen with Misty Mountain and the E. coli and things like that. So it was a good meeting, but it was a hard meeting.
Okay. And remember attending a separate hearing here before the commission on the other case regarding Mr. Blevins' wells and well systems?
Yes.
And that was about the PSC staff requesting an appointment of a receiver for the various wells and well systems, right?
Yes.
That was case number WO 2024-0036. And did you testified at that hearing?
Yes.
And were you you were cross-examined by Mr. Blevins?
Yes.
And just generally, what did you testify about? Without going into too much detail, but
Yeah.
just generally, what was your testimony about then?
We focused more on safety. Why is it an issue that these are non-compliant wells? Why is it an issue that things were not resolved at Misty Mountain? Ownership came up a little bit because it was confusing. It still is. Things still feel like they change really frequently as far as who owns what or who really owns what. And so that was really the focus, I think, of the last one.
And do you still have those safety concerns going forward?
I do, because there has been a complete stop in submitting routine samples.
I don't know if I need to offer this. I guess I'd offer the transcript from that last proceeding, WO 2024-0036, that Ms. Johnson's testimony be entered into evidence or be officially recognized or officially noted. I guess
You're asking me to
I
take
guess-
official notice of her testimony in
Yes.
WO 2024-0036?
Yes. And I have a copy of just her testimony, if I can provide copies of that.
Mr. Blevins, do you have any objections to the commission taking official notice of Ms. Johnson's testimony in the receivership case, the one you were here on before, in this case?
I'm not sure I understand that when you
Okay.
use the word receivership.
Okay. You remember we had an evidentiary hearing before, and you were here, correct?
Yes,
And that was on staff asking to have a receiver appointed for your systems, correct?
that's correct.
And at that hearing, Ms. Johnson here testified.
I don't remember what her what she said.
Okay. Do you want to take a moment and look over the testimony that was given before determining whether or not you want to object?
Maybe I should. Is this it?
No. Oh, is it? Okay.
Yes. I've got copies of her portion of the testimony, if I can get those.
Why don't we just do this as an exhibit? I think
Okay.
at this point that would be easier, so
Okay, that's.
if you've got that available, if you'll bring me one, I'll mark that.
Okay, and that would be Exhibit 9, I believe.
Correct.
And specifically, in that transcript, there were, I think, two volumes of transcripts for that hearing. And her testimony can be found at pages 206 to 241 of Volume 2 of the transcript.
And is that what you've separated out, or is it just
Yes.
all of volume 2? Okay.
Yeah, I separated that out. Do you want copies?
I need at least one copy. Let me know when you're done reading, Mr. Blevins. Let's go off the record for the moment. Go off the record to give Mr. Blevins a little bit of time to read. Mr. Blevins had some questions about the testimony in the prior cases, and we started to discuss that off the record, and I felt that it would be better if we discussed that on the record. So, Mr. Blevins, you indicated you had said a number of things there, but one of the things you said was this is testimony from the WO 2024-0036 case. You were here during that testimony for both Ms. Johnston and Mr. Cloverside. And they have essentially asked to offer, right now, I believe, the testimony of Ms. Johnson from that hearing into evidence, and I believe they're going to offer the evidence from Mr. Cloverside into that. And so you have a right to look at that testimony and make any objections if you want to. The fact, as you brought up off the record, the fact that you didn't object at the time that at the time the testimony was made is not relevant to whether or not you want to object to it being offered in this proceeding. But that testimony is currently not a part of this proceeding.
I would rather not see it part of this proceeding.
Okay.
I
Well,
think that's already been done. Is that true or not true?
well, I'm not sure what you mean by true. Was the testimony given? Yes, the testimony's given. Did the commission order a receivership at that time? No, it didn't. It ordered status reports to see if you remained engaged with DNR, since it appeared the Department of Natural Resources was still engaging with you. So I don't believe a final decision has been rendered in that case. But the commission did not order a receivership at that time. So you're objecting to offering Ms. Johnson's testimony into this case, correct?
I would think that would be my answer to that, is I would object to it, simply not to muddle up what we're doing right now.
Okay,
My
so
opinion.
your objection is that it is, that it will muddy it up, that it's,
I don't know what verbiage should be used, but that being already done, don't want to see it come up again in this proceedings here, that these proceedings would be on their own merits.
okay, response staff?
Well, a lot of the, that was a separate case number. But a lot of the information that was provided in that hearing, I would present again in this hearing. I could, my thought was that rather than going through the same questions over, getting the same information in this hearing, that I would offer her testimony from the WO case into evidence to shorten the time that it's going to take to get that same evidence in here today.
Okay, I'm going to overrule the objection and admit Exhibit 9 onto the hearing record. So Exhibit 9, the testimony from Jackie Johnson from WO 2024-0036 is admitted onto the hearing record. And you may continue.
Okay, now, as part of your testimony in that case, you discussed a number of DNR documents outlining and setting forth various violations found by DNR regarding the wells and well systems operated by Mr. Blevins.
Yes.
And did those include the 3 public water systems that we've been talking about right now?
Yes.
Misty Mountain, Rolling Hills, and Charity?
Yes.
Okay. And the documents that you testified to or about in the WO 2024-0036 case, those were all applicable to these 3 water systems?
Yes.
Okay. I'd ask that I have the documents from that case, that hearing, and I'd ask that be entered into evidence as Exhibit 10.
And what
Those documents, it was the affidavit of business records, and then the, I guess I can show her. Do that.
well, give a copy to Mr. Blevins so you can look at it while you're.
All right, I've handed you exhibit, what has been marked, or would be marked Exhibit 10. Do we have a copy?
And are these just DNR records, is that correct?
Yes. And were those the documents that were entered into that, the receivership case in that hearing in October?
I think so.
Okay. Okay, so there was a business record affidavit and the DNR records? Is that what's in that packet?
Yes.
And those, is that what was entered during your testimony in the WO 2024-0036 case?
I say I think so because it's a lot of documents, but these would be the things that we discussed. So,
Okay.
yes.
And I'd ask that, I guess this is Exhibit 10 be entered into evidence?
And all of these documents were offered during her testimony in the WO case?
Yes.
Mr. Blevins, do you have any objection to the Department of Natural Resources records that were offered as part of Ms. Johnson's testimony in WO 2024-0036?
No objection.
Exhibit 10 is admitted onto the hearing record. May I have a copy?
If I could get you a copy
When you're done.
when I'm done, yes. It was Exhibit number 7 in the WO case, just by the way, just for the record. But I can get a copy of that too, if you need another copy.
I think there'll probably be one left over here in a minute.
Okay.
I just need a copy for the commission.
Okay. If I can get that after today's, when we go on a break.
That would be fine.
Okay. So are there any other actions being taken against Mr. Blevins or his well systems that he operates other than the two that we just discussed, the Misty Mountain and the Rolling Hills?
We are still in the process of negotiating an administrative order on consent for charity.
And can you explain where are you in the process there?
I sent a proposed AOC at the same time as Rolling Hills, so at the beginning of January, sent the same failure to respond letter. I sent a revised proposed AOC, and then after that point, Mr. Blevins let me know that he has repaired the well that's known as the concrete well on PP, because I had corrective actions to plug that well and said that it was not in use and things that no longer made sense in the order. I've asked for additional documentation for justifying that. And so Mr. Blevins also let me know that he has sold one of the wells to a resident, and so I've asked for documentation of that. And then once I have that information, then I will evaluate whether I need to revise the AOC again. It has been a protracted negotiation process because the circumstances keep changing and because there was that lack of response at the beginning.
Okay. And that lack of response from Mr. Blevins?
Yes.
And when do you anticipate filing that?
The deadline for the information that I requested was the 22nd, so that has passed. I still need certain documentation to be able to evaluate whether I can change it. I will follow up with Mr. Blevins outside of this hearing, hopefully tomorrow if we have time, or on Wednesday, because we're to the point where if we're not going to reach an agreement, we don't need to continue trying to negotiate an order. We can instead move forward with a unilateral order, which is that order that becomes effective with just the department's signature.
And is that what you would end up doing with the charity AOC, or is that?
Specific to charity, and that's our normal process. If we cannot reach an agreement on an administrative order on consent, then we will move forward with a unilateral order.
Okay. But you haven't made that decision yet?
No, because the deadline just happened over the weekend. So I did check my email this morning before I came, and I did not have any emails from Mr. Blevins. He gave me a paper when I came in this morning. I haven't had time to review, but I still don't think it's probably going to be sufficient for the documentation that we need to make any changes to the order.
Now, does this seem to be a pattern with Mr. Blevins?
It has been for these orders that, it'll seem like we've got a good handle on what's going on, and then something changes. So, for example, the Taylor well changing ownership, or the this charity well that's gotten fixed, and the charity well that's been supposedly sold. Despite having continued conversations with Mr. Blevins, I just found out a week ago about the charity well allegedly being sold to one of the residents. And that's been included in the order that's been sent out multiple times. So it's been a challenge to reach an end point because it just feels like things keep changing.
And I'm sorry if I, kind of going out of order. When we were at the hearing last time in October, on the WO 2024-0036, there was somebody else from DNR that testified,
Yes,
and who is that?
Sebastian Cloverside.
Okay. And do you remember what he testified to?
Mr. Cloverside was involved before me. He was in the original group of people that went out and visited the system and tried to identify where the wells were, who owned the wells. He was with Central Field Operations and was receiving a lot of the concern calls. He was actually visiting the system for compliance assistance and collecting samples and things like that. So he had a much more hands-on, in-person experience with the system compared to me.
And so his testimony was basically about what his involvement was?
Yes, and that the required actions related to his visits to the system.
Okay. All right, I'd ask that Mr. Cloverside's testimony in the WO 2024-0036 case be entered into evidence. His testimonies, specifically at pages 124 to 202 on volume 2 of the transcript.
Mr. Blevins, do you have any objection to admitting Mr. Cloverside's testimony onto the hearing record?
I have no objection. It's already been done.
Well, it was done, the testimony was taken in the previous hearing. This is one for which I believe administrative notice is appropriate, or official notice is appropriate, since Mr. Cloverside is not here to lay any foundation.
Okay, then I would ask that the commission take official notice of Mr. Cloverside's testimony in file number WO 2024-0036 in this case.
And Mr. Blevins has already indicated he doesn't have any objection to it being admitted onto the hearing record, so I will take official notice of Mr. Cloverside's testimony from the WO 2024-0136. I will note that, that given Ms. Jean's testimony, that may affect the weight that's given such to Mr. Cloverside's testimony, but I will take administrative notice of it.
Thank you.
Go ahead.
Now, it's our understanding from the testimony that Mr. Blevins, well, does he have a certified operator currently for his systems?
No.
And is he supposed to have one?
Yes.
And what requires him to do that, to have a certified operator?
It's required by 10 CSR 60-14.
And what's the purpose in having a certified operator? Why does DNR have that requirement? Do you know?
I don't know why DNR came up with it, but I know that in Chapter 14 in 10 CSR 60-14, it talks about how the properly certified chief operator is responsible for operational decisions, day-to-day operation of the system. They're the ones who are ultimately responsible for the quantity and the quality of the water. And do DNR regulations require a public water system like Mr. Blevins' systems to have a plan for a backup or replacement certified operator? Yes, systems that are required to have a properly certified operator are also required to have a backup plan. It doesn't necessarily have to be another employee, but it has to be a plan for what would happen if they lost their operator.
And did Mr. Blevins have such a plan?
It appears that he did not, since he doesn't have an operator since his left.
Okay. And that was Ms. Lori Jean?
Yes.
And is that who you've been dealing with as you've been involved in Mr. Blevins' case? The certified operator, that's,
Yes.
and so, does he have a deadline to get a new certified operator?
Well, you're required to have one as a community water supply at all times. So it's not like there's a deadline to replace your operator.
Okay, so as soon as she tendered her resignation, the requirement was that he would have somebody to immediately follow her?
Yes, and that's why they have to have a backup plan.
Okay. And, do you know what what the reasoning is behind that? Why these systems need to have a certified operator?
It's built into the regulations. Because this is a community public water system, community public water supplies are required to have a properly certified operator.
And what happens if he does not replace Ms. Jean or get a new certified operator, anything?
We will send a letter of warning the month after we become aware of a system. We run that report once a month. So once we're aware that a system doesn't have an operator, we add them to our report and we'll issue a letter of warning. And then the next month we'll issue a violation for not having an operator. As long as a system continues to be without an operator and doesn't have a specific schedule of compliance for how they will obtain an operator, we will continue issuing violations each month.
Okay. And have you done that with Mr. Blevins' systems?
Yes, we have issued a violation for not having a properly certified chief operator.
Okay, so he got the warning letter first, basically, and then after that he got, how many violation? So has it been, what, April, May, and June?
I know he's had at least one. I'm not sure if he's gotten the next one yet. I didn't look at the timing for when that first one was issued. But until we have a specific plan, so it can't just be saying, I'll get an operator. It has to be specific, such as I'm taking an exam on a certain day. Then we can pause sending additional violations until that plan either doesn't happen or doesn't work, or the system returns to compliance and then we don't need to issue any more violations.
And so has Mr. Blevins done anything to replace his certified operator that you know of?
He told me that he's been looking. I was contacted by someone who was interested in potentially becoming a contract operator. It was a very savvy person who was familiar with our website Drinking Water Watch and saw that there were violations, saw that there were enforcement actions. That person was able to read the order for Misty Mountain. And I think that person ultimately decided that they did not want to be the operator. They told me that there was an issue with what they would charge versus what Mr. Blevins said he was willing to pay. So I do know he was at least attempting to find an operator at that point. I don't know about his actions since then. Mr. Blevins and I spoke last week, and I talked to him about if he wanted to get certified, that there are classes you can take. You're not required to take a class unless you fail the exam 3 times, and that's built in, again, into that 10 CSR 60-14. So we identified a couple of classes that were within a reasonable driving distance. So one was in Bell, one was in Springfield. The public water supplies, these community public water systems get vouchers each year that can be used to cover the cost of taking a class, cover the cost of taking a test. So I talked about that with Mr. Blevins, that he could get certified on his own. He does not have to take a class. He could just take an exam. And I talked to him about how we now have more testing options. So you can basically test 24 hours a day, 7 days a week at your convenience. You can either test at home, but there are some requirements for that, or you can go to a testing location to do it. And so he did indicate that he would be interested in getting certified himself.
Has he done anything? Has he actually taken any of those steps that you know of?
I gave him the phone number and contact information for the person at Springfield. It sounds like he indicated earlier that he has spoken with them about getting registered for a class, but that class doesn't start, I think, until July. And so if he does end up taking that class, it hasn't started yet.
Okay. Do you have any concerns whether Mr. Blevins will be able to get a new certified operator or become certified himself?
I think with his years of experience, and he says he has good knowledge of, how to operate the system and everything, he could take the exam and see if he passes it. And then he would know if he needs a class or not. But lots of people feel more comfortable if they take a class first. He should, as long as he attends the class, be able to pass it, and then take the exam and hopefully be successful.
And if he doesn't do that, do you have any concerns about whether Mr. Blevins will hire a new certified operator anytime soon?
Yes.
And what are those concerns?
I'm concerned that he won't, because he said that he's having trouble finding an operator. And can I answer one more? I've also provided information, as has one of my coworkers, about how to find a contract operator in the area. We have an online system where you can search for people who are certified. You can search by county. You can click multiple counties. If you're not finding them in Pulaski, you can select counties around it. And I've provided those directions. My coworker has provided those directions as well. So Mr. Blevins does have the tools to identify operators in his area. But the one issue with that is that unless an operator provides their contact information to be listed on the website, it will just be a name. It won't have a phone number. And there are not a lot of contract operators available in the state.
Okay. So other than what you've testified to and what's been entered into evidence, is there any general testing or oversight going on of Mr. Blevins' wells or well systems?
Not at this time.
And has that been since March
Yes.
or February?
Pretty much since March. So Lori Jean did collect samples in February. And so since then, we haven't had any samples.
Okay, and do you have a concern about that?
Yes.
And what is that?
That we don't know if the water is bacteriologically safe.
Okay. So the problems that you testified to last time, do those continue to show up?
I'm trying to think of the timeline. I guess the Topa well had already collapsed by that point. So there hasn't really been a big change in what the concerns are. Topa well still has collapsed and not been plugged. That is a concern. There was a well at Charity, the PP well or the concrete well, that was not in use, but also not plugged, and that was a concern. There was the Taylor well, which had not been in use for years and was not plugged, and that was a concern. Those circumstances have changed for some of it because the Taylor well, as of June 6th, is producing water again. Mr. Blevins says that he's repaired the Charity well. So that has kind of changed, but the Topa well is still collapsed and not plugged, and that is a concern for us, but that's why we included that as a required corrective action in the AO.
And how would you describe Mr. Blevins' responses to getting those things fixed?
He tells me a lot that he will do things, but I agree with what was said earlier about how there's a different sense of urgency. I definitely stick with deadlines. We run by rules and deadlines, and it feels like Mr. Blevins, while he'll say that he's going to do something, he's not moving at the same speed that I wish he would. So a lot of deadlines just are not getting met. For example, if I send an order and it has 30 days to respond or sign, and that day comes and goes, and I have to send a letter to tell you that you've missed your deadline and give you a new deadline, and that comes and goes, it gets frustrating that we're very specific about what needs to be done and when, and then it doesn't happen.
Does that seem to be a pattern with Mr. Blevins?
Yes.
Does he seem to, does Mr. Blevins end up usually doing what he says he's going to do with regard to fixing things or taking tests, taking the samples?
I would say no, and sometimes he just does different things. So, for example, we put in the order for charity in the revised proposed AOC that the PP well should be plugged because it wasn't in use, and instead he fixed it. So that was unexpected. There's just been a lot of things where, you know, we've said you need to do a specific thing, like when there was the ongoing E. coli issues at the topo well, and we had a very specific list of actions that needed to be taken. They didn't happen. Instead, the well collapsed and it got connected to the county. And so even times where it feels like we have a very defined path forward, it doesn't go that way.
Okay. And do you have concerns about his response, his ability to, the way he responds like that?
I do. It's hard to believe that he's going to follow through on things when he says he will and then he doesn't meet the deadlines.
Oh, I think this was part of, oh, this was this one, okay.
Anything further from staff at this point?
If we could have just a second, please. Or make sure I have all the exhibits that I wanted to include.
Okay.
Can we make a 5-minute break?
Here in just a moment, I think we're going to take a break, Mr. Blevins, if you can hang on just a second.
Okay.
Okay, thank you. I don't think I have any other questions.
Okay. Mr. Blevins had asked about a break. I also think I'd planned to take a break after this witness, but this has taken a little bit longer than expected. So why don't we break until it's now 3:34? Why don't we take about 11 minutes and be back here at 3:45? Okay. We'll go off the record. Commissioner Coleman, who has been listening via WebEx, has joined us in person in the hearing room. Welcome, Commissioner. When we left off, it was just about to begin cross-examination by Mr. Blevins. Mr. Blevins, did you have any cross-examination for this witness?
I just have a couple questions.
Go ahead.
The, Ms. Johnson, state of Missouri doesn't have very many operators that are available to Pulaski County. Do you know about how many would be available? When I go to the website that you gave me, I didn't find any. I did talk to a few, but to no success. Is there a number of operators that would handle Pulaski County, in your knowledge?
I'm not sure. In order for there to be a phone number listed on that search that you're referring to, an operator submits a form to ask for their information to be shared. So there are likely other operators on that list of results that you get that are potential contract operators. They just don't have their phone number listed.
Yeah, I didn't find any. The one that I talked to, their cost was more than what all these wells brought in on a monthly basis. Impossible to do. My discovery is that there are not very many operators available out there to be contracted with. I've chosen other avenues to go, but
Mr. Blevins, do you have a question?
that's what I'm trying to get to. Let's see. Do you remember, you mentioned the one well that was sold. Do you remember talking about that well sometimes in the first of the year that would not be included in charity?
There was talk of potentially selling the well. I spoke with the person who was going to maybe buy it, and then I never heard anything else about it actually being sold. And I did send you orders since then that contained that well, and even then you didn't tell me that the well was sold.
Well, that was the document I handed to you today. I thought that you had already been informed with it sometime back. I have no further questions.
Any commission questions? I hear none. I've got a few for you, Ms. Johnson. I heard you indicate, you said it was case law that kind of established that if you're a single owner of multiple wells, that can be put together as one public system. Is that correct?
Yes.
How were the systems determined in Mr. Blevins' case?
I was not a part of that decision, but from what I've read in our internal documentation, proximity was part of it. So like for Misty Mountain, those 5 wells that were originally identified were all together and serving homes that were all in close proximity, and it's known as a subdivision as Misty Mountain. So that one made sense for grouping those. And then Charity has interconnected wells, so that one was really simple, and then Rolling Hills just has the one well.
Okay, thank you for that explanation. Now, you remember testifying here in WO 2024-0036, correct?
Yes.
And that was, in that case, the commission staff was requesting that the commission appoint a receiver to take over Mr. Blevins' wells, correct?
Yes.
Now, at that time, you had indicated that you were working on a non-compliant well agreement for Misty Mountain. Am I correct in that?
Yes.
And that was not completed before the end of the hearing. And that hearing was in October, I believe, 25th, for a few days around October 25th. On December 20th, the commission issued an order basically asking what the status of that non-compliant well agreement was. But my understanding is that an administrative order was instead issued on December 28th. Is that correct?
Yes.
Why was an administrative order issued instead of completing the non-compliant well agreements?
So the The corrective actions that would have been included in a non-compliant well agreement are part of that AO. The decision was made to go with a unilateral order based on the history of the E. coli violations and lack of corrective actions at Misty Mountain, and specifically on Topo Drive, and then also the lack of corrective actions for other things associated with that from Mr. Blevins. We determined that the best course of action, instead of this extended negotiation process, would be instead to go with the unilateral order that requires the topo well to be plugged, contains those non-compliant well agreement corrective actions, because the other wells are still non-compliant, and then had some other things built in, including the administrative penalty.
And that administrative order was appealed to the AHC, correct?
Yes,
And ultimately, it was determined that order stood.
yes,
And so that's currently, that is a current enforceable order.
yes.
But that's not the case with the other two, correct?
Incorrect. So Rolling
Okay.
Hills does have an effective order. It contains a waiver of right to appeal. And actually, let me,
Okay, so that's a consent order.
yes,
So what he's done there is it is an agreement where he's agreed to give up the appeal, and then there's some enforcement action that can be done.
and I just want to verify real quick that that is part of that order. Yes, so there was a waiver of the right to appeal for the Rolling Hills administrative order.
And you said there is or is not a one out in regard to the charity?
I'm still trying to get a signed order for charity.
Okay, so there's one consent order and one administrative order, is that correct?
Yes,
Now, originally, no, I'll come back to that. Originally, it was my understanding from the last hearing, from the receivership hearing, that it was DNR that put Mr. Blevins in contact with Lori Jean. Is that correct?
I don't know about that. I don't know how she came to be his operator.
Okay, so you don't know if DNR assisted him with that.
DNR isn't allowed to endorse any specific products or businesses, so I think it would be unusual for us to say you should hire this operator. Instead, we can provide, like Mr. Blevins was referring to, we have an online website where they can look up certified operators in their area, but I don't know how Lori Jean was identified and how she became his operator.
Okay. Now, Mr. Blevins has indicated that he's had difficulty finding a system operator for Pulaski County. And it appears that the commission staff is having difficulty finding a potential receiver if somebody were to take over Mr. Blevins' systems in Pulaski County. So I'm taking it that this is a fairly rural, out-of-the-way place in which it's hard to get people to handle these small water systems. Is that correct?
While the neighborhoods themselves are a little bit remote, they really are not that far from cities like Waynesville and St. Robert. You don't have to hire a contract operator. You can also be certified yourself. You can have an employee get certified. There are other options besides just hiring someone who already is a contract operator.
And that's actually where I was going. Given the lack of available resources, wouldn't it make the most sense for Mr. Blevins to become his own system operator?
I think so, especially because DNR provides vouchers which could cover the cost of getting certified.
Now, I know that staff had asked you what had been done, and you'd listed a few things. One of the things that was absent was the Taylor well. Now, we had a procedural conference a while back, and Mr. Blevins had expressed at that conference that he had until the beginning of June to get the Taylor well operational. Was that part of one of the AOCs or the AOs?
At the time that we wrote the Misty Mountain AO, the Taylor well was just not functional, and so we've had to kind of pivot a little bit with how we're handling that, because while the Tigger HOA had a deadline. It changed a little bit, but it was all that first week of June for when they were going to cut off the water access to Taylor. Mr. Blevins he told me he had it tested privately through the health department, determined that it was bacteriologically safe. I haven't seen those results. That wouldn't be a sample we could take for compliance. But we don't have any sort of sampling history for that well. So outside of the order, because this was a new development since the order was issued, we have set up the sampling schedules for the other testing that's done for community systems, things like nitrate and organic compounds. There's several. And so we have those kits. I don't know if he's already gotten them yet or if they're just still on the way, but he needs to collect those samples so that we also know that they're not only bacteriologically safe, but chemically safe.
Is there currently any outstanding order, consent, or otherwise in regard to the Taylor well?
The Taylor well is already included in the effective order, the AO for Misty Mountain. But Mr. Blevins did not own the well at the time that we wrote that order. So, like, we have the letter in there that already is addressing the change in ownership of the Tigger well. This was a very recent development. It just happened a few days ago about the Taylor well. We may have to, again, write something about how we're going to handle that. I don't know if we'll have to have any sort of separate order. I don't know how that's going to happen because we have an effective order for the circumstances that happened at the time, but they keep changing.
And I'm trying to follow this because the thing is, it seems like I guess there's a break in the system that I don't quite understand, because it seems like that you're telling Mr. Blevins he has to do these things, and then when he doesn't do them, that there are penalties issued, and these penalties are predominantly financial, which, of course, you'd want to see that money actually go into fixing the system instead of necessarily going towards fines and penalties. But I also understand that there's not a lot of other actions that DNR can do prior to the Attorney General's office getting involved. So how do you currently see Mr. Blevins, how does DNR currently see Mr. Blevins' situation getting resolved?
As far as the orders that I have, I do not believe Mr. Blevins will meet his deadline for tomorrow to complete the corrective actions for the Misty Mountain AO. So the next step would be referral to the Attorney General's office. With the Attorney General's office, we'll be able to also address the additional violations that have happened since then, the change in ownership of Tigger, the change in ownership of Taylor, the fact that this keeps changing. If we do have resolution, if it does get taken care of, that's great. We would love to be able to have compliance. That's the purpose of the order, is to identify what the issues are, the steps that need to be taken to correct it. Like, that's the goal. And as far as the penalty, that's built into statute. It's a common question that comes up is, if a system is supposed to be fixing things, why do we charge them money that won't go toward the system? But that's in statute. That's one of the things, though, that, I don't know, in an AO, it's not as negotiable, but if we had penalties in the other order, that's something that could be negotiated, is the amount of the penalty. I don't know that he is going to be successful in returning to compliance with Misty Mountain. Rolling Hills is really straightforward. He just needs to submit that documentation that we've asked for. He needs to register his operating authority, and he needs to get a permit to dispense. Charity, if we cannot reach an agreement within the next few days, I mean, so much time has passed, so many requests for changes. If he's not going to provide the information, if we're not going to reach an agreement, we're going to stop trying to reach an agreement, and then we could refer it to the Attorney General's office. The issue is, though, that one is really a non-compliant well agreement. It's us saying, we know you have a well that wasn't built to standards, but we will let you continue using it under certain conditions. If he's not willing to agree to that, I don't know that the Attorney General will also then try and enforce an order to let him continue using non-compliant wells. He may, in fact, lose the ability to use those wells if it goes to the Attorney General's office.
Thank you. Hold on just a moment. Mr. Blevins has indicated that he's continued to do stuff such as activate the Taylor well in response to being asked to remove that grouping of houses from the Tigger well, which I guess was supplying it. And he's also indicated other items he has done. Would it be fair to say that while Mr. Blevins has accomplished some actions, these are not the actions that DNR has wanted him to accomplish?
Yes.
So if DNR has a priority right now, what would that priority be? What if he were to do one thing, what would be the most important thing?
Collect routine bacteriological samples from all of the systems.
Okay, thank you. Any recross based upon bench questions? Mr. Blevins, do you have any questions based on my questions?
I have no questions. I've got a lot of information or detail I could provide, but I don't think that's the time to provide that.
No, you'll have an opportunity to do that when you testify. Any redirect from the commission staff?
No.
Okay. Ms. Johnson, you may step down. Now, unfortunately today, because of childcare duties, I am not going to be able to run this hearing late today. I would be able to tomorrow. So why don't we go ahead and start our next witness? And if we get through him, great. And if not, we will continue him on to tomorrow.
Call Dalton Young.
Mr. Young, would you come up to the stand and raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Please be seated. Staff, go ahead.
Good afternoon. Could you please state your name and spell it for the record?
Dalton, D-A-L-T-E-N, Young, Y-O-U-N-G.
And by whom are you employed and what's your position?
I am the Public Drinking Water Unit Chief for Central Field Operations for the Missouri Department of Natural Resources.
And how long have you been employed in that position?
In this current position since October 2nd of 2023, but I've been with the unit since September of 2021.
Okay. And just generally, what do you do in the position that you're in?
So currently I supervise 3 inspectors and an engineer who conduct compliantary inspections on public water supplies in the 9 counties of central Missouri. And that details doing compliance inspections, compliance assistance, technical assistance, really anything regulatory for these systems. We're the boots on the ground type of people.
Okay. And before you became supervisor, what were your duties and responsibilities then?
I was just an inspector, so I would go out to systems who had to do their 3 or 5 year mandated inspection, or I would provide technical assistance or compliance assistance for systems that requested it. I also served as the enforcement coordinator for Central Field Operations, so I was involved with sending systems to enforcement or referring them to enforcement if need be.
And are you familiar with Mr. Blevins?
I am.
And how did you become familiar with?
I was part of the initial team that went down there to the Misty Mountain area in June of 2022 to investigate some concerns we had about health-based issues with the water. And through that process, we met Mr. Blevins when he was activated as a public water supply in August of 2022.
And when you became supervisor, did you replace anyone?
Yes, I did.
Who did you replace?
I replaced Sebastian Cloverside.
Okay. So you took over the case relating to Mr. Blevins as supervisor for, you replaced, whoops, sorry. So basically you took over the case from Mr. Cloverside
Yes, ma'am.
as supervisor. Okay, I'm sorry. And how long so you've worked with Mr. Blevins since 2022?
Off and on, less directly. When I did talk to the Misty Mountain system, I usually talk to Lori Jean, the designated operator, to keep information as streamlined as possible. Ms. Johnson would speak to Travis Blevins directly, and I mostly spoke to customers and residents in the area, as so we did not cross information or did not have multiple sources of information.
And so what is, with Mr. Blevins' case, what kind of contact, I guess you said what kind of contact you have with Mr. Blevins, but with his case overall, what kind of contact do you have with that? Or what's your involvement with his particular case?
We did the compliance inspections. Me personally is more of the concern route, so whenever we got concerns from residents in the area, my main job was to go down and investigate those concerns, either do sampling or look at the wells themselves, or I would contact Lori Jean, the operator, about compliance issues that we had. I did speak to Mr. Blevins in the field in person a few times, but when I did contact him, it's mostly through phone, as he was pretty responsive in that area.
Okay. And do you do inspections then and write reports?
I do.
Okay. And with regard to Mr. Blevins' systems, what kind of, what's been the result of the inspections over the last couple of years that you've been working with him?
So Sebastian did the inspection in June of 2022. When he left in September of 2023, I took over the required actions of the case, and so I worked with Lori Jean to get the system back in compliance and get updated information from the system about that. Past that, I conducted 2 leveled assessments on the charity public water supply, which happens when you get multiple BACT samples that are positive total coliform in a certain amount of period. But that has been my only official reporting I've done since being in this role.
Okay. And since you've taken over as a supervisor for Mr. Blevins' case, could you explain how his compliance has been?
Yes. As regarding to the official report from 2023, all of these significant deficiencies from that report have been resolved. There are what we call unsatisfactory findings, which is usually more of a paperwork issue or just a way a system's ran and not really a physical component or a health and safety hazard. Some of those unsatisfactory findings are still out of compliance. Regarding the permit to dispense, we are lacking one of those. The lack of a backup operator and fees from last year that are not paid is the report findings that are still out of compliance. Outside of that, there are out of compliance issues with not taking bacteriological samples for all 3 systems, not having a certified operator, and there is a current violation for not correcting a level 2 assessment from December of 2023, or 2022, I'm sorry.
So he hasn't fixed the problems that were in December of '22?
That is correct.
What problems were those?
That was regarding the topo E. coli issues we were having up to that point. The corrective action was to find and fix the issue or plug the well, and neither one of those things have happened.
What did happen?
The well failed in March of 2023.
Okay. And Ms. Johnson has testified that since March of this year, there have not been any water samples taken or provided to DNR.
Not that were compliance samples from Travis or a certified operator.
Okay. Was there something else? I mean, was there something?
There was a concern that I worked 2 weeks ago at the beginning of June on Topo Drive with a resident who was very concerned that they did not have any sample results from samples being taken the last few months, and they requested that my office go down and do technical assistance to just get an eye on the water So I took a non-compliant sample, which means it doesn't go in the record of the system. If it comes back bad, we don't issue violations for it. It's just kind of an overall view of how the water is. I did collect one of those that was total coliform positive.
Okay. And so that was for that, do you remember which well? I'm sorry, you might have already answered this question. Which well was that one for?
It was for the Topo Drive, the well that is currently connected to Pulaski County number 2.
Okay. And,
Can you clarify this for me? I'm not understanding. So the well is collapsed, but it's connected to something?
Yes, so the physical well that is in the ground, the casing collapsed and dropped into the aquifer. There is a hookup, or what we call a bypass, in the well house. Sometimes we call it an emergency connection, where if that well fails or they need to turn it off for any kind of maintenance, they can bypass that well if they're interconnected to another nearby water supply, which happened in this instance. They found a interconnection with the county district, Pulaski County number 2, and they were able to bypass that well, shut off the piping around it, and use the water from the county to supply those houses. So it's kind of like having an interstate with an access road. The interstate's closed, but there's still an access road where you can kind of go around.
I guess my question ultimately is there a danger of cross-contamination from the topo to the public water supply, or the Pulaski water supply too?
There is, if the topo well is not properly plugged and there's somehow still piping from that well into the distribution system, there can be backflow if Pulaski County number 2 loses pressure, or if there's a major leak and stuff gets in there and backflows. That is a possibility.
Okay, thank you. That's what I wanted to know. Go ahead, staff. Sorry for the interruption.
thank you. Ms. Aslin's going to hand you what's been marked. I believe we're on Exhibit 12.
Exhibit 11, I took official notice of
Okay.
the Mr. Cloversize testimony
Okay.
instead of making it an
Sorry.
exhibit. Thank you.
Now, do you recognize what I've handed you?
I do.
And what is that? Can you explain
There-
what they are?
Yes, this is 2 separate documents. One is a level 1 assessment from having multiple positive total coliform samples. And the second one is a level 2 assessment, which happens when you have multiple level 1 assessments. So it's kind of an upgraded assessment.
Okay, and so the level 1 is the first one?
Yes,
Is
ma'am.
that like, you get the level 1, and then if you don't fix level 1, you get level 2?
Not necessarily don't fix. It's more if you keep getting bad samples, then it gets upgraded to level 2. In most traditions, a level 1 assessment is conducted by the system. A level 2 is conducted by our office.
Okay, and is that what happened here with these 2 documents?
No, what happened with the level 1 is it was coming up on the due date for the system, and so these can actually be conducted over the phone with the operator, which is what I did in this case. I called Lori Jean on, looks like November 13th, and conducted this assessment with her over the phone.
And what does, can you explain what, were there violations noted?
There was no violations noted with either one of these assessments.
Okay. And was there any concerns that you had when he was issued these level 1 and level 2 assessments?
Not at first. With most of these assessments, it's due to operator sampling error or weather conditions. I think we noted on both of these that it was windy or raining during the time of sampling. Bacteriological samples are so finicky that wind, pollen, even your breath can make a sample bad. And so we think that's what happened in this case, just due to all the rain we had in early November, late October is the reason for these. And with that, there's really nothing the operator or the system owner can do other than sample when it doesn't rain.
Okay, and so did you do that?
We informed the operator, Lori Jean, to monitor the weather and take samples when, maybe after it rains, wait a week or two, or and clean the sample tap really well before sampling.
Okay, so what was this level 2 assessment, the second document, was that as a result of the level 1?
Yes, it was a result because they got 2 level 1 assessments in the same 12 months. That second level 1 assessment gets upgraded to a level 2, which is when our office goes physically on site to conduct the assessment, which is the same as an inspection, just without the paperwork. So it has the same thoroughness as a compliance inspection.
And were there any assessment, level 1s or level 2s assessed for level 1 or level 2 assessments done for any of the other wells? This one, I believe, is Charity?
I believe last year, I'm not sure what the date was, there may have been a level 1 for Rolling Hills. We don't really see too many compliance issues coming out of that system. Misty Mountain, there have not been since Topo has been hooked up to Pulaski County 2. Before then, there were numerous level 2 assessments due to E. coli on the Topo Drive well. But nothing since March of last year.
And so are these notices new violations that have occurred since October of '23?
They're not necessarily violations, they're just more saying you have an issue, please fix it. And that's what the assessment does, it helps them identify what the issue is to fix. So that's been the only new thing since October.
Now you're saying there's an issue, do these normally go out to other water systems when, just as a matter of course, or?
Yeah, these are fairly common, especially in heavy rain seasons like early spring and late fall. These assessments are pretty common for systems who have maybe a more shallow well or an operator who may not know to not sample in the rain or just not clean a sample tap. These are a pretty common thing in my office.
And your office has collected or has received water samples from each of the 3 public water systems. And just, is that right?
Up until March of this year,
Okay.
Yes, ma'am.
And in comparison, what was the level of those? I mean, were there concerns with those, or what was the problem with those?
Out of Charity and Rolling Hills, there wasn't too much concern. We had a few total coliform positive samples here and there. That's typical. I mean, that can happen to any system. E. coli is what we are worried about the most. And out of Misty Mountain, I believe there's between 85 and 90 compliance samples since August of 22, and 55 of those were total coliform positive, and 35 of those were E. coli positive.
And that was since, I'm sorry, you said since,
August of 2022, when they were activated as a public water supply.
okay, now compared to other water systems, how does that compare?
Depends on the system. The system of similar size and operation, we may see an E. coli once every 3 or 4 years. They are not very common. If there's an E. coli, there's usually contamination of the well itself or the lines. It's very rare that some systems get them. Some systems may never get one. One may get 10 a year. It's very hard to tell. But based on similar systems, similar size, I'd say once every 3 years.
And so compared to that, the 35 E. coli samples that came back, that's out of the ordinary?
Extremely, yes.
And so what was the difference between the chloroform, the first type of sample?
So In
and
order
E.
to have E. coli, you need to have total coliform. Total coliform is a pocket of bacteria that E. coli is housed into. So you can have total coliform or TC and not have E. coli, but you have to have TC to have E. coli. Very rarely will E. coli ever be present by itself. So it's kind of like you need a house to live in. The TC is the house and E. coli is the person.
Okay. And so 35 of those samples had enough to have E. coli.
Yes.
And just for the commissioners, and in my advocation, what kind of concerns does that bring to DNR when there's so many bad samples?
It brings a lot of concern. It lets us know that there is an active issue somewhere in the system, whether it's the well or the lines. One bad sample here and there you can kind of write off, but when you have this amount, there's an active issue somewhere, and E. coli can lead to numerous health risks and sicknesses, and we did get a report of a couple sicknesses, which led us to investigate the area.
And was Mr. Blevins notified of these, these E. coli and other samples?
I believe so. At least Lori Jean was always notified. When a sample comes into my office for results, we notify whoever is listed as the chief operator. Unless it's the owner themselves, then we'll call the owner. But Lori Jean was always notified, and I believe she would have forwarded that information onto Mr. Blevins.
Okay. And so these 35 samples, was that over the course of the time that you testified to, was there more E. coli samples at one point than the other, or was that just spread out?
It was a pretty constant stream. As Lori Jean testified earlier, there would be some times when the well would come back clean. You go back the next day and you have E. coli. So TC moves in pockets, so it's not like someone's dumping in a steady stream of it. You may catch a pocket one day and then not the next, but these E. colis were never hit or miss. They were always pretty constant.
And as far as you know, has that been corrected?
Since the topo well has collapsed and they are now connected to the county, we have not received any more E. coli samples out of Misty Mountain.
What about, and any from the other two?
We have never received an E. coli from Charity or Rolling Hills.
I'll move that Exhibit 11 be admitted.
Mr. Blevins, do you have any objections to admitting Exhibit 11, the level assessments documentation, onto the hearing record?
No objection.
Exhibit 11 is admitted onto the hearing record.
And you work with Jackie Johnson on Mr. Blevins' case? You have,
Do, yes.
and can you describe how that works between your office or your section and hers?
Yeah, we routinely share information on ongoing cases. Jackie has a numerous amount of cases, some that are in my area, some in other jurisdictions. And so anytime I learn something new or she learns something new, we always share the information together.
And so that would include all the samplings and if there were any violations that...
Yes, ma'am.
So do you have any ongoing concerns about any of the well systems?
I do.
And what are they?
The lack of sampling for all three systems, especially with the Taylor well now up and running. We have zero sampling history from back T or any kind of chemical samples from that well, and we have no idea what kind of water that well is pushing out. Mr. Blevins did indicate he took a sample to the county health department that tested clean for any kind of bacteria, but we do not count the county health department samples as regulatory samples for DNR.
Okay. And So not having those samples, does that bring you concern about his ability to provide safe and adequate water for the residents of those systems?
Yes.
Can you explain that?
How so?
Well, why would not having those samples, how would that make that a DNR concern for the safe and adequate drinking water?
Because we have no idea what people are actually drinking or bathing in. We don't know if there are pockets of TC or E. coli running through those wells. We don't know if they have high levels of nitrate. We don't know if there's any volatile or organic chemicals in there. We don't know if there's any type of cyanide or any type of inorganic chemicals that are in those wells. High iron, manganese, calcium, nitrate, nitrite. There's a bunch of chemicals we test for that we just don't know what's in those wells and what people are drinking.
And that's just with regard to the public water systems that are regulated by DNR.
Yes, ma'am.
To your knowledge, Mr. Blevins operates other well systems that are not regulated by DNR, is that correct?
I believe so. I don't have a list of exactly what those are, where they're at, but I only know a few of them.
Okay, but he does have some wells that he's operating that are not, as far as you know, regulated by DNR?
I believe so, yes.
And so having not, since they aren't regulated, you don't get any samples from those?
That's correct. I don't have any other questions.
Mr. Blevins, do you have any cross-examination for this witness?
I do, yes. The testing that you mentioned a while ago done at the topo, what residence was that done on?
That was an anonymous concern, and I am not at the authority to give that address out.
Yeah, was it done on the Pulaski County water side or the distribution side?
That was on the distribution side after the connection.
Okay. You did mention also about the possibility of the well that is non-operational there. There's no well or anything there inside or down in the copper. You mentioned backflow. How would that backflow if the Pulaski County is going direct into that distribution system and not going through that well whatsoever?
If there is a connection with the well into the distribution at any point and Pulaski County loses pressure from a major line break or a well goes offline, it will back siphon what's ever down in those lines, air, dirt, bugs, stagnant water, back into the distribution system.
Even though there's a valve there to keep that from happening?
The foot valve, yes, but we've known that foot valves are not reliable to prevent stuff like that.
How about a regular valve?
Possibly, but we also don't know how many connections were on the well itself. You could have a distribution piping, but in the case of a pitless adapter, there could be one 10 feet down, there could be one 12 feet down. We physically do not know what's down there.
If that line was also capped on that side of the hole, between the distribution lines and the well hole, if that was capped in between there, does that prevent backflow?
It can if it's physically severed.
It's what?
If it is physically severed, yes, it can.
Okay, so that can be prevented on backflow?
Yes, sir.
Okay. Were you aware at the time that when the E. coli problem was existing in that topo well area, which I'm, of course, well aware of that myself, because I think we all tried to investigate and find out what was going there was 2 other wells drilled during that time. Were you aware of that?
I am.
Could that drilling have caused a lot of the E. coli possibly from overflow or flushing or?
It is technically possible, but in this case, I don't believe so because the E. coli was present before those 2 wells were drilled.
Yeah. It kept coming back though. Well, you would agree with that. So it was during that period of time that E. coli kept showing up regardless of what was done. The actual sample of the Taylor well water, different, still on Misty Mountain, I did not do that sample. That was done by Rick Guile. He was the operator, not the DNR operator, but the...
Mr. Blevins, you're testifying. Is there a question in there?
Well, my question is were you aware of that test being done by Mr. Guile?
I am aware of the test being done. I did not know who conducted the test. I just know that a report from Jackie Johnson to me was that the test was clean of any bacteria.
Yeah, okay. No, there were no further questions.
Any commission questions? I hear none. I've got maybe just a couple. You said you had indicated that a couple people in the area had gotten sick. Is that from E. coli?
It's from what we believed E. coli. There was never any doctors who backed it up. If they even went to a doctor, they just claimed they had waterborne illness.
Okay. Were these people that would have been Blevins customers?
Yes.
Now, you had indicated that outside of the Topo well that there were no E. coli samples taken at any of Mr. Blevins' other wells. Is that correct?
Yes.
And that Topo well collapsed. And this is more just a concern of mine than anything else, that I've noticed that Mr. Blevins will be proactive in repairing something when he sees a way that he can do it. And so I know that DNR, that their stance is, we want the Topo well capped. And that's one of the things that they've asked to have done. But I also just heard you tell him that if he physically severed it from the Pulaski water supply number 2, but that won't cap the well, correct?
Correct. We would require a plugging, which involves pouring cement down there.
So that doesn't really resolve the issue.
Correct.
And so my concern is that he's going to hear that, go out and do something that does not really resolve DNR's violation. So that's the comment and not really a question. Now, looking at Exhibit 11, these level assessments, you had indicated that, or you testified on the stand that these are issued and then they're given a corrective action, correct? And in this case, it says there was issued, there were 2 tests that were bad, and the response of the defects noted was windy or raining during sampling conditions and no corrective actions needed at the time. You just want them to sample better.
Yes. Usually we do a verbal recommendation of watch the weather report, do not sample during heavy wind or heavy rain or directly after, and wait a few days.
What, outside of the sampling violations, what health or safety violations have occurred since this was before us on the receivership action in October?
Since October or before October?
Since October.
Since October, we have no official health and safety violations I'm aware of, besides the operator. I'm not sure if that is a health and safety violation or a compliance violation.
So the two ongoing things are no operator and no regular sampling.
Yes, sir.
Thank you. Those are all the questions I have. Mr. Blevins, do you have any cross-examination based on questions I just asked?
No, no, sir.
Any redirect from staff?
Just had a couple questions. Now, you said you just testified, or in response to a question, that severing the topo well, that would not resolve your concern, DNR's concerns?
That is correct, because even if that well is capped, someone can come by with a pipe wrench or a crowbar, uncap it, and then you have a direct hole into the aquifer where, as Mr. Blevins mentioned, there are 2 other wells connected to that aquifer downstream, and there may be more in the area on the same aquifer. So if someone comes by and dumps something down the well or contaminants get inside of it, you're not contaminating other wells in the area as well.
Okay. So he could sever it and you still have problems?
Yes, ma'am. We would require a physical plugging with concrete.
Okay. And that has not been done?
As to my knowledge, no.
Okay. And, okay. I don't have any other questions. Thank you.
I have one question that occurred to me. How many, do you have any idea with a well of, say, this size, how many yards of concrete you're looking at to plug it?
I do not. Our Missouri Geological Survey would know that answer, but I do not.
Okay, thank you. Any questions based upon my question, Mr. Blevins?
No, sir.
Any further redirect based on that?
No. Thank
Okay. Mr. Young, you may step down. Thank you for your testimony. Staff, you may call your next witness. Well, actually, I'm just gonna ask. You can call your next witness, or we can take this witness up first thing in the morning. I have no preference, but I am going to call it right at close to 5.
Why don't we start with the next witness tomorrow morning? Because I don't think that I'll get through this witness necessarily before 5, and I'd rather have it all in one day, in the same day, than try to split it up, if that's okay.
No, I think that's acceptable. Okay, before we break until tomorrow, is there anything else the commission needs to take up at this time? Staff?
I don't believe so. We need to get you copies of Exhibit 10, I think, but I think that's,
If you just want to bring that tomorrow morning.
I can do that, sure.
Mr. Blevins, is there anything the commission needs to take up today before we break for the day?
Yeah, no.
Okay. All right, we will break until 9 a.m. tomorrow, and I will adjourn for the day. Thank you very much.